Yeah.
Good morning, Mr.
Vargas.
Ferrer. Okay,
Hey.
both of you here. Mr. Vargas, what are you doing today to get rid of this case?
Well, I tried to contact one of the ADAs yesterday and sent an email, so hopefully they've got that.
Are you going to confer
case
then?
wa- Yes, sir.
All right, you're number one to confirm, Mr. Vargas. All
Thank
right,
you.
let's see. Let's see some hands on attorneys that want to confer. Sharon Thorne,
Good morning, Your Honor.
good morning.
I have a Justin Lee Garcia, 681-659, and I would like to confer.
681-659, you say?
Yes, sir.
Justin Garcia.
Yes, sir.
Good morning, Mr. Garcia. Sharon, you're number two to confer.
Thank you.
All right, Forrest Good,
Good morning, Your Honor.
good morning.
Forrest Good on behalf of Mary Petersack. I'm here on client Amadio Narvaez on page 6, case number 685800.
685-800. Amadeo Narvaez,
Yes, Your Honor.
is he present?
I'm not sure, Your Honor. I will.
Amadeo Narvaez, answer if you're present.
I see him.
Mr. Nar-
I see him on the Zoom. He's muted.
I see him. Okay, Mr. Narvaez, I'm marking you.
Okay,
present. I'm marking him present. Mr. Forrest Good. What are you conferring on behalf of Ms. Petersack?
Yes, Your Honor.
I know her as Petracek, but also there's a different pronunciations and she's not partial to any particular one.
Whatever's easiest for people to say, I think, is her main thesis there.
All right. Kenneth Bell.
Good morning, Your Honor.
Good morning, Ken.
I have Leslie Leha. She is present on the in the meeting, and it's
All right.
under case number 602742.
6027, number one on the hit list, huh?
Number one on the hit list. If we could talk to probation, we sent in the paperwork showing she's completed everything a couple times. I just need to make sure they have it.
All right. Let's see if we can get Ms. Luna to talk to you. Charlie Jones.
Good morning, Your Honor.
Good morning to you.
Sir, I have Mr. Carlos Lara Jr. and he's cause number 687741. We'll be happy to meet with the prosecution.
687741. You're on page 7, huh?
Yes, sir.
Already. Is Mr. Carlos Lara present?
Yes, I saw him. a little while-
Carlos Lara, I see him. You're muted, Mr. Lara, but I see you. All right. Charlie,
Yes, sir.
Yes, sir. I'm present.
you going to confer?
I'll go to room 5. Your Honor.
All right, Carlos. Charlie, you may confer.
Yes, sir.
Catherine Valenzuela, good morning.
Good morning, Your Honor. I'm here on Uvaldo Peña. It's on the top of page 4, 682019.
Thank you for that quick assistance there. 682019.
Yes, and I,
Uvaldo Peña. Uvaldo Peña. Uvaldo Peña is absent at this time, and be sure you get him to report, Ms. Valenzuela.
yes, can I still confirm?
You're gonna confer?
Yes, Your Honor.
Alrighty. I will show you present and conferring. Abel Dominguez.
Good morning, Judge. I am here on Jeanette Garza, cause number 681248.
681, 248. Middle of page 3.
Yes, Judge.
Jeanette-
This will
Jeanette
be,
Garza. Jeanette Garza. Appears, oh, there she
I
is.
think she's waving, Judge.
Are you the one that says with the red blouse? Okay, you're muted, but that's okay.
It's okay.
And Mr. Dominguez, that's gonna be a plea today?
it is going to be a plea. I emailed the coordinator, my client's email address yesterday. So we just need to get the paper and get it filled out. What time would the court like us back for this plea?
Linda?
We will be doing Please Able in person tomorrow or Thursday in the afternoon about 1.
Tomorrow or Thursday? Okay. Here.
More accurately, we start at 1:30, so. But,
Okay.
You might can come in with your client and get all the paperwork done ahead of time. Thank you.
Okay, we can do Thursday at 1:30. That'll be fine.
Already.
Okay.
David Christian.
Good morning, Judge.
Good morning.
Page 6, Jackson Benavides, 687-626. He is present on the Zoom. Judge, we have applied for PTD. We've already conferred. And so we're just waiting if we can get a new date. I think that will resolve itself shortly.
When did you make the application for PTD?
I want to say about 3 weeks ago, Judge.
All right, let's give you 30 days. See if we get all that settled down.
Yes, sir.
Thank you, David. All
Thank
right,
you,
any
Judge.
other attorneys present?
September 31st, David.
Yes, ma'am.
I mean,
Thank you.
I'm sorry, August 31st.
Okay, thank you.
All right, any
Yes,
other
Judge.
attorney present?
Judge,
Yes,
Judge, this is Attorney Paul Vasquez. I don't have a
Paul
page
Vasquez,
number, but
okay.
I do have a case number 676998. Edgar Gutierrez.
676998, top of page 3. Edgar Gutierrez. Edgar Gutierrez. Golly, Edgar, you sure
There
look
he is.
like.
He's listed as iPhone, Judge.
I see it.
He's waving his hand.
He's waving his hand.
Yes.
How many of you know Leo Alvarado?
Neil Alvarado, I do not.
That's Judge Alvarado's father. He's passed away, but man, you know, Edgar, you'd pass for his twin. Obviously, not the. You're a little heavier looking, but man, you look like it. God bless his soul. And who's this for Neil Kalfas?
I am Judge Paul Vasquez. I just need to confer with a prosecutor.
I'll show you present for Neil Kalfas, and I'll show you conferring. Next attorney, let's see some hands. Show me some hands. Attorneys.
Judge. John Pettis here.
James Hunt.
Or not.
John, I'll get you next. I don't see your hand. Okay, James Hunt, what you got?
I've got, he has 2 cases on page 5. First case number is 685-019.
685-019.
Yes.
Yael Amador.
Yes. I see his name. I believe he's present, but I would like to confer.
Where's Mr. Amador? Wave your hand or speak up. Oh, yeah, ma'am, I'm sorry. I thought it was a male named Yael.
It's on the.
All right, Mr. Hunt, what are your wishes?
I would like to confer.
And you are listed to do so. John Pettis.
Yes, Judge. I've got 2 of them. I've got Mr. Caleb Flores, case number 687-674, as well as case number 687-673.
Okay, 687-673. That is Caleb Flores.
Yes, Judge.
Is he present?
He is, Judge. He is under the name, where'd he go? I just had him. Carlos Rojano It's his, he's using his.
Is that his alias or he's using somebody else's phone?
He's using his father's phone, Judge.
All right.
So he's there, Judge. We just got hired on this one, so we're still getting discovery together. I would love to confer with the state, except I prefer conferring on the next setting when I have actually reviewed everything.
All right, so we'll just reset you 30 days. Let you let the dust settle for you a little bit.
I appreciate it, Judge. Linda, you got a date for me?
August 30th.
August 30th. Let me double check, make sure that works.
All right,
August
I see.
30th. Wait, Judge, sorry, I still got one more.
Okay.
Sean will have to wait.
Hey.
I've got Mr. Adam Gonzalez, 628-845.
628.
Yes,
845.
845.
Okay. This one we're going to be bumping you around because it's been reset 16 times.
Yes, Judge. I was only just appointed to it this past May, and I haven't had any contact with my client besides this morning. So I'm asking for one more reset, and then if we have to set for trial, we set for trial.
We'll reset you 30 days, and I'll hold you to that.
Yes, Judge.
All right.
Then the same date, August 30th?
Yes, both. Yes.
All right. My clients are excused, Judge?
Yes, sir.
All right.
Sean
y'all can log
Simpson.
off.
Thank you, John. Sean
Good morning,
Simpson.
Judge. Your Honor, I've got Jonathan Vasquez, and he is on the bottom of page 1, or the second from the bottom on page 1. And I can see him logged in as iPhone.
As what?
He just logged in and it's under iPhone. He's waving his hand.
There you are.
This is his
Okay.
first time to Zoom.
It's Jonathan Vasquez and Mr. Simpson is present. Mr. Simpson, what are you doing?
Your Honor, I just got the video and he's going to come in and watch it with me either today or tomorrow. And so if I could get a reset to do that, we will be ready to make our decision at the next setting.
30-day reset.
Thank you, Judge.
August 30th.
Yes, ma'am. Thank you, Linda.
You're welcome.
Thank you, Sean.
Thank you, Judge.
Justin Folks.
Morning, Judge. I'm here this morning on Roberto Gonzalez. He's present. On this case, Your Honor, I've been
Give me a case
talking with
number,
the state.
Justin.
Give me a case
Yes,
number.
Your Honor. Yes, 681-368.
681-368.
Look
And
under
660-341, Your Honor, is the other case. And then there's one more.
Wait.
page,
Hold on.
Judge, page 2, 660-341.
Okay, it's under the other. 660-341, top of the page. All right, this is gonna be a plea?
But possibly, Your Honor, we're trying to finish up some courses for my client and also just trying to work out last minute details on his case, Judge. If I could get one more reset.
It's been reset 13 times. I will give you one reset, but this definitely for this position.
Thank you, Your Honor.
How long, Judge?
Is he present, by the way?
He is, Your Honor.
Okay,
How long should I give the reset for?
give him 30 days. That's all they'll need.
Okay, 30 days, Justin, August 30th.
Mr. Folks, is that enough or you have problems with that?
No, Your Honor, that's perfect. That's perfect.
All
That'll
right.
give me enough time to iron out the last few little details on the case.
Very good. Then it's a done deal. All right.
Thank you, Your Honor.
Next defense attorney that's ready. Give me some hands. No defense attorney left. All right. Then I'm going to call the regular docket. The defense attorneys can confer with the state. We'll start off with 610-020. Well, I better enlighten you. There you go. I was keeping y'all in the dark. 610-020, State versus Misty Menard. And the attorney is Jessica Gonzalez. Both of them are absent. Let's see. 630018, State versus Isaiah Brown. The attorney, Joe Stenberg. Isaiah Brown. Isaiah Brown is absent. Joe Stenberg, no answer. 635378, State versus Crayon, Jack Stevenson. Jack Stevenson, absent. No attorney. 637548, State versus Vicente Lopez, attorney. Javier Padilla. Vicente Lopez, wave your hand or speak up. Vicente Lopez. All right. Absent. Attorney Javier Padilla, no answer. 642326, State versus Joshua Payne, attorney. Ashley Morgan.
Judge, that's a motion to suppress at 1:30.
Good morning,
1:30.
Judge. I spoke with Ms. Morgan yesterday on Mr. Payne, I believe it was. I believe because she has two that are set for motion to suppress. One of her clients is actually in custody in another county. So we have she's going to take a reset on that one. I just can't remember which one it was. It's either Holder or Payne that's in custody in Gillespie.
Okay, this one does not show that he's in custody, Mr. Payne.
Yeah, it would have been another county, I think, Judge.
All right, well, we'll try and figure it out. 651734, State versus Aiden Myers, attorney. Larry Meadows.
Mr. Meadows, ill, Judge.
All right. Aiden Myers, he's in jail. So he is present involuntarily. 663602, State versus Paul Rodriguez, attorney. Robert Gebbia.
Present, Your Honor.
Good morning, Mr. Rodriguez.
Sir,
You expect Mr. Gebbia to join you this morning?
I was told that one of them would be here. But I have
All
no
right.
idea.
For right now, there's no answer from him or his partner. 666307, State versus Jason Holder, attorney. Ashley Morgan.
That's the other motion to suppress for later today, Judge.
Okay. 666441, State versus Donald Paxson rather. And Andrew Freilich is attorney. That's been reset. 667076, State versus Alisa Garcia, attorney. Jessica Gonzalez. Both are absent. Go on to the next page, page 3. 677744, State versus Anita Braxton, no attorney. Anita Braxton. Anita Braxton is absent. 681441, State versus Joe Trevino, attorney. Stephen Nicholas.
Yes, I'm here.
I'm present, Judge.
Good morning.
Good morning, Judge.
What are you doing this morning, Mr. Nicholas?
I'm doing pretty well. Thank you. Thank you much for asking.
Are you going to confer on this? What do you want to do?
Yes, sir. And there is a felony pending also, Judge.
Right. I've got that noted. I'll show you conferring, and if you have a felony pending. Yes, sir.
Okay. Thank you.
You're welcome. 681894, State versus Clint Moore, attorney. Todd Overstreet. Clint Moore, attorney. Todd Overstreet. Both absent. Going to page 4. 682327, State versus Frederick Munoz, attorney. Cesar Serna.
I'm here, Your Honor. Frederick Munoz.
Good morning, Mr. Munoz. Are you expecting Mr. Serna to join you this morning?
I believe so. I talked to his office this morning and yesterday afternoon.
Very good. I haven't heard from him, but we'll wait for him. 683-475 State versus Eric Rodriguez, attorney. Dylan George. Eric Rodriguez, I see you with your hand up. You expect Mr. George to join you this morning? We'll have to wait for him, sir. Six 579 State versus Miguel Sanchez, attorney. Karen Corby. Miguel.
I got a call from Karen Corby. She says she has had no contact with him.
All right, we'll show him failure to appear then. 683-594, pardon me, 683-596, State versus Christopher Payne, attorney Rafael Leal. Christopher Payne is absent. Rafael Leal, no answer. Page 5. 683-636, State versus Richard de los Santos, attorney. Gary Hillier. Richard de los Santos.
I'm here, right here. I'm here. You see me? I'm
Where you
here.
at?
Right here. I'm here.
Page 1,
Okay.
Judge.
All right, Mr. de los Santos, I'll mark you present. Are you expecting Mr. Hillier to join you this morning?
Yeah, he was supposed to. I don't know what happened. I got to call him and find out.
Okay, do that. Meantime, I'll mark him as not answering and get him to show up. 684-320, State versus Trenton Habdi, attorney. Ninfa Carrillo.
Good morning, Your Honor.
Good morning.
How are you?
I am well. How about you?
I'm okay.
What says
Mr.
what
Britton
says that?
Humphrey is online.
I'm sorry?
I'm sorry, I didn't mean to speak over you.
That's all right.
My client's online, Mr. Habdi.
Very good. And what says Atascosa County? Are you still out there?
I'm mostly in San Antonio, but I
Oh,
still
really?
go back and forth.
Very good.
Yeah.
So what you going to do? You going to confer this morning?
Yeah, but this misdemeanor that this case that's in your court, Your Honor, is as a result that it came out of a felony, so there's a felony pending.
All right. I see 4 felonies pending, so
Yes, sir.
you're
He's got quite a
busy.
bit.
You're busy. Good client.
Yes, sir.
684-385, State versus Lauren Reyes, attorney. Jessica Gonzalez. This is listed as a plea. Lauren Reyes. Lauren Reyes.
Presence in the courtroom.
Okay, good. And Jessica Gonzalez. No appearance. We'll wait for her. 685-019, State versus Yael Amak, what? Oh, Amador. And we already checked you off on that. All right. Next page. 687-571, State versus Alexander Blaine, should be Raimundo Aleman, attorney. Alexander Blaine. Alexander Blaine is absent. And Raimundo Aleman, no appearance. 687-584, State versus Kimberly Sosa, attorney. Anton Hayek, the third. Kimberly Sosa is absent. Mr. Hayek, no answer, no appearance. 687-655, State versus Sway Zavala. Attorney, Gail Calderola.
Yes,
Sway Zavala,
yes, I'm here.
where are you? Wave your hand.
Right here.
There you are. All right. I found you. Thank you. And are you in communication with Ms. Calderola?
No, sir.
All right. I'm more showing her no appearance at this time, but we'll wait for her.
Yes,
She'll
sir.
usually show up. 687-584, State versus Alexandria Falcon. Attorney, James Mayra. Alexandria Falcon is absent. James Mayra,
Judge, she's incarcerated.
she is, that's correct. She is in jail. Sorry about that. James Mayra, attorney. No appearance, no answer. 687-687. Sabrina Ramsey. And that is Joe Stenberg. Both are absent. 687-694, State versus Nathan Mendez, attorney. Jeannie Cupid.
Present, Your Honor.
Good morning, Mr. Mendez.
Good morning.
You sure yourself be named Samsung?
I'm new to Zoom. I'm sorry.
I say your name is Samsung, SMA 1360. All right. Miss Cupid, no answer. 687-703, State versus Matthew Cruz. That's attorney is Albert Van Cleve III. Matthew Cruz.
Yeah, I'm here, Your Honor.
There you are. Good morning to you.
Good morning to you too.
Are you in contact with Albert Van Cleve III?
I tried to get in contact with them and they were busy. And then I called yesterday and she was already in court, I believe, or he was in court. So I haven't really been able to talk to him about the case.
All right. Well, apparently he should know that you're here, so we'll wait for him.
Okay, thank you.
687720, State versus Frederick Nardi. No attorney.
I'm present in the court.
Frederick Nardi, you say he's in the court?
Yes, sir.
Good morning to you.
Good morning.
Have you hired an attorney?
No, I haven't hired an attorney yet.
Can you afford to hire one?
Yes, not right now though.
Well, not yet, not right now. Are you able to hire one?
Yes.
All right. I'm going to give you 2 weeks to come back with your attorney.
Okay.
August the 9th. Wait for me in the courtroom and I'll give you a reset form.
Okay.
All right, Mr. Nardi, thank you.
Thank you.
687759 in jail. State versus Javier Sanchez, attorney. Edward Cano. Mr. Cano, no answer. Addition, Ulises Campos, 654-680. Ulises Campos.
Judge, that's going to be at 1 o'clock with Veronica
Okay.
Alegreta.
1 o'clock, not 1:30.
No, 1 o'clock.
Okay, somebody's changing the rules on me here. All right, that is the docket for this morning. If anybody thought their name should have been called and either came in late or did not hear it called, please raise your hand, or if you're in the courtroom, come up to the rail.
Your Honor, my name has been called.
Ezekiel, what is Ezekiel's
Rosales.
last name?
Rosales.
Rosales. All right.
He was on yesterday's docket, if I'm not mistaken. Yes, he was on yesterday's docket. He failed to appear yesterday, Judge.
Ezequiel Rosales, who's your attorney?
Brenda,
I don't have one, sir.
Who do you show? Do you show somebody?
I have Brenda Livingston, and he was on yesterday's docket. He failed to appear yesterday.
Uh-oh. All right, Mr. Rosales. You need to get a hold of Ms. Levenstein. She's been appointed as your lawyer in case you don't know. What are you charged with?
The indecent exposure.
Indecent exposure, okay. All right. How many times has he been reset? Do you know?
He's been reset 9 times, Judge.
Uh-oh. All right, Mr. Rosales, get in touch with Ms. Levenstein. If you'll hold on, my coordinator, Ms. Flores, will give you her contact number. Make sure you get in touch with her right away because you've been reset too many times. You're gonna have to start moving on this case, or she will. All right. Anybody else that needs to speak up or wave their hand so you can get my
Good morning,
attention?
Judge.
Good morning, Mr. Rodriguez.
Yes, Judge. I'm present for Mr. Rodriguez. This is Charles Peters.
Okay. What's the case number on?
663602.
663. All right. Now this shows Gebbia. You're working with Robert.
Yes, Your Honor.
Y'all didn't contact us or tell us anything, so make sure you do that in the future. What are you gonna do? You're gonna try and confer?
This morning, I believe we were going to request a jury setting. I can confer. I'm actually in court in Austin this morning, so we would just request a jury setting. I can confer with the state off the docket, and I can follow up with Mr. Rodriguez.
We will set you for trial.
That will be August the 26th.
You got it?
I'm just checking my calendar, Judge. That should be fine, Judge. I have a couple other matters that are set on that date, so we'll just see which one is ready to go.
Ready. You're reset.
Maybe
Jesus Vargas, did you want to?
Yes, Your Honor, we conferred with the ADA and basically said we can put on the trial calendar. We'll take another peek at it and see where we go from there, either trial or something else.
So you're set for trial?
Yes, Your Honor. Whatever, I think he said that there's an October docket, so.
I have August 26th, Mr. Rodriguez.
Well, he wanted October to look over the case and see where he wants to go on it, either a dismissal or something.
Well, we're setting you want a trial setting. It's going to be for the 26th.
Of October?
No. What is it?
August 26th.
Well, okay. I spoke to the prosecutor. He wanted to see about October.
Who wanted to see October?
The ADA that I just spoke to.
Okay. Well, we'll have to check it out. But meantime, this is the date you get. Anybody else need to report or to let me know that you're here?
Your Honor, this is Jason Goss. I'm representing Ricardo de los Santos.
May we be excused, Your Honor?
Yes, sir, Mr. Vargas. Thank you.
Have a nice day.
Okay, again, who's this?
Jason Goss, Your Honor, representing Ricardo de los Santos.
Give me a case number, please.
Case number is 683-636.
On page 5. All right. Now I show Gary Hillier, and who are you now?
Jason Goss, Your Honor, all of us represent, we're all from the same firm, LaHood Norton Law Group. We're all on the notice of representation, but the clerks just pick one name out and then put it as the attorney.
All right.
But we are all his lawyers.
All right. Jason Goss, and what are you doing?
Well, Your Honor, this is an early day setting. It looks like we still need some discovery. And so that's really all I was going to request from the prosecutor.
I'll give you 30 days reset.
Okay. Thank you, Your Honor.
You're welcome.
August 30th.
Thank you.
Anybody else need to check in?
Yes, Your Honor, I just conferred with the state. This is Sharon Thorne on behalf of Justin Lee Garcia. State wants to reset it for 30 days for a possible PTD.
And give me a case number, Ms. Thorne.
Oh, I'm sorry, 681-659.
681.
659.
Page 3, Judge.
Yeah. 681-659.
Yes,
and
sir.
You want to do what now?
State wants 30 days for a possible PTD.
Reset PTD.
August 30th.
Thank you. May my client and I be excused.
You certainly may. Thank you, ma'am.
Thank you. Have a great day.
You too. Who else needs to check in?
This is Kenneth Bell on Leslie Leha, 602742. Would you put me in with the prosecutor?
I think Linda should. If she hasn't, she will. You were number 3 to confer.
You're in 4. Where did he go?
I was in 4 probation.
Yeah, just wait there and they'll be right with you, Mr. Bell.
Thank you.
All right. Ms. Luna, they're waiting for you.
Judge,
Yes.
on page, this is your bailiff on page 4. First one on page 4, Peña Ubaldo.
Ubaldo Peña.
He is present here in the courtroom, Judge.
Yes, okay. Yes, marked him present.
Okay, and then on page 6,
Yes, ma'am.
687-641, present in the courtroom.
Garcia.
Yes, he is present in the courtroom, and he says he is going to hire an attorney.
All right, Mr. Felix Garcia. I'll give you 2 weeks to come back with an attorney.
Don't let him leave until I give him reset forms, Michelle.
All right, he's before you, Judge.
All right, Mr. Garcia, my court coordinator will bring you out a reset form. You're going to come back in 2 weeks with your hired attorney, okay?
Yes, sir.
So wait in the courtroom. Thank you.
All right, yes, sir. Thank you.
Who else? Ms. Grabowski, anybody else in there?
No, Judge, I'm gonna check on, I have 2 that are here, but they're not on the docket. So I was gonna
Okay.
run it by Linda back there in the office.
Very good. Thank you.
You're welcome.
All right, then nobody else needs to check in. Court will be in recess. Yes, sir. Somebody's waving from inside a car. All it says is iPhone. Who are you?
Christopher Perez.
Christopher. I'm sorry?
My attorney is Brenda Louise Levison also.
I'm having trouble understanding what you said. Say it again.
My attorney is also Brenda Louise Levison, and she said she'll be here in a minute.
All right. And what is your name again?
Christopher Perez.
Christopher Perez. Linda?
Yes.
What's the case number?
100,694.
Say again?
100,694.
No, you've got probably your SID number. The case number is different.
He's not
No.
on the docket. He was one of the ones, Judge, date of birth 11/6/2003. He was one of the ones I was gonna check with Linda, 11/6/2003, Perez Christopher.
Okay. Linda, find him?
I don't show him, but I'll take care of it in a minute, Judge.
Okay. Stick around there, Mr. Perez. We'll try and get it squared away. Jessica Gonzalez, the late Jessica Gonzalez.
Good morning, Judge. I'm sorry. I was announcing on a trial docket in County Court 11.
How are you this morning?
I'm good, sir. How are you?
I am well. Good to see you.
Good to see you.
You got two cases. Starting off
Actually-
with one that's a fugitive, and that's Misty Menard.
Yes, Your Honor. That one we're gonna need to approach. I filed a lack of due diligence, a motion to dismiss for lack of due diligence and speedy trial violations. There's also an active, or should be an active, it was signed by Judge Harrell back in June, a bench warrant to be able to bring over Miss Menard. She's actually in state custody. However, they have failed to execute the warrant they have against her for over a year now, hence my motion to dismiss.
You mean you were demanding a speedy trial for your client?
I know, Your Honor, it's so shocking.
How unusual, huh?
I
Okay,
know.
we're gonna set that and we will issue the bench warrant.
Okay, well, Your Honor, I think had been trying to speak with Daniel to see if they were going to be going forward on it. Can I be put in a breakout room once I take care of this plea to be able to speak to Daniel to see how they're going to proceed on it?
With whom you want to?
I believe it's Daniel Escobar that's still in here.
No. He's not in here anymore.
Okay,
Try either Kenny Delco or there's a Kyle Vance that's from the 290th, and the two of them been working together on the cases. So
Kyle's from the
Linda showed
290th?
that we need to set it for hearing and
Bench warrant.
bench warrant.
Yes, sir.
All right, next one, you have another one, Jessica, maybe two, but I know you have one more at least.
I have
Here
two
it
more,
is.
Your Honor.
Garcia, Elisa Garcia.
Again, the same issue. I need to approach on a speedy trial, and again, Daniel Escobar was supposed to be reviewing it for a dismissal since her two other co-defendants had their cases dismissed.
All right, we'll set that also for a hearing. Obviously, she's not in jail, but she did not show up this morning.
Right, but did she have notice?
Pardon me?
I don't know if she's had notice, Your Honor. This case has been old and pending. It comes from County Court 2. I don't know that she's had notice of today's hearing.
I see. Okay, well, if we don't hear from her in 1 week, I will issue a warrant. So try to track her down. All right. Set this one for a speedy trial also, Linda, but it'll be on condition that she reports. Otherwise, we'll issue a warrant for failure to appear.
Yes, sir.
That's on condition, further condition that we have given notice to her. All right, Jessica, you have another one?
Yes, Your Honor. Lauren Reyes is set for a plea this morning.
Case number.
It is 684-385.
Six, 684-385. That is set for plea. Lauren Reyes is present,
Correct, Your Honor.
and now you are. All right. Very good. We'll get the paperwork on that. We'll get her done.
She's finishing up her personal data sheet. Do you want me just to take it back to the clerk, or is Linda in her office?
I'm in my office.
Okay, I'll bring it back to you when I have the paperwork done.
Okay.
Thank you.
All righty. Anyone else need to check in? Forrest, good? You just sitting there? What do you need?
Good morning, Your Honor. I just finished conferring with prosecution. I'd like a reset date. They need more time to review the case before they give us an offer.
Give me the case you're working on, case number.
Sure. 685800.
685-800.
Page 6.
Yes. The state wants what, 30-day reset?
I believe so. Yes.
August 30th.
All right.
You're welcome.
Thank you, Your Honor.
You're welcome, Mr.
May my client and I be excused?
You are excused. Thank you. Anyone else checking in? Nobody else checking in. All right, then we'll be in recess till further notice.
Judge, this is Kenneth Bell on Leslie House, the number one on your first page when you get a chance.
Ken Bell, what can I do for you?
I've talked to Kenneth, the prosecutor, Kenny, the prosecutor. They're going to try to get me an answer back by this weekend. I've asked them to consider the term it untaxed with the deferred and tax. She's worked real hard on this thing, but she's still missing just 3 hours and some money. And she's got 5 other irons going with kids and everything else. So at this point, I need a reset.
About 2 weeks.
2 weeks should be fine. If we can set it on a Friday, Your Honor.
Linda,
August the 12th?
is that a Friday?
Yes, sir.
You got your Friday.
That'll work. It's my birthday, but I'll do it for this time.
That's your birthday?
That is my birthday.
All right. Well, we'll have to wish you a happy birthday ahead of time, and maybe we'll remember when you come in.
All right, sir. August the 12th it is. Thank you, guys.
All righty. Ken?
Yes, sir.
If you're going to be celebrating on your birthday, we can give you another date.
No, that's perfect. This is my niece. I'll be here for that. No problem.
All righty. Very good.
Thank you.
Name 5.
Your Honor, I've been waiting in a breakout room. I don't know whether
you're down the line a little bit on the list.
Oh, okay.
But
All right,
they'll get to you.
Just checking, Judge.
All
Thank
right.
you.
If, let's see, right now, it's right at a few minutes before 10. If you
Okay.
haven't got anything going for sure by 10:30, come back and yell at me and I'll make something happen.
Yes, Your Honor. Thank you.
You're welcome.
Hey, Linda, it's Paul Vasquez. I've been waiting for a prosecutor to come into the breakout room to confer, and no one has yet to
I
come in.
know, I have a bunch of people, so you're just gonna have to wait. I think it looks like we might just have one prosecutor.
Okay. In the meantime, can I have my client be excused?
Yeah, sure. That's fine.
Okay, Edgar, you can go ahead and log off. I'll continue waiting. Okay.
Thank you.
Yep. I'll go back in the breakout room, Linda.
Okay.
All right.
Morning, Beth.
Howdy.
Hi, Mr. Jones, how can I help you?
Okay, I talked to the DA and there's a problem with the videos. They're corrupted. So we're gonna drop the setting. And I'm supposed to call DA IT to see if they can fix it, or they're gonna do a, burn a CD.
Okay, what's the case number, Mr. Jones? I'm sorry.
It's number 687741. Carlos Lara.
Okay, so do you want to reset for about 30 days?
That would be terrific.
Okay, and you said videos are what again? I'm sorry.
They're corrupted. I get into them and I don't know, something happens to them.
Okay. All right, so I'm going to give you August the 30th.
Let me check my deal here.
Okay.
Nine o'clock.
Yes, sir, on Zoom, yes.
Okay. Put that in my.
Hi,
Elizabeth.
may I come?
Okay, Mr. Jones, so I have you reset to August 30th.
Okay, am I, thank you so very much.
Welcome.
Can I leave now?
Yes, sir.
I'm done. Right?
I'm sorry?
I'm finished for the day, right?
Yes, you are.
Bye-bye.
Morning, Elizabeth. How can I help you?
May I confer on Matthew Cruz, please?
It's Matthew Cruz. Can you give me a case number for Mr. Cruz, please?
And give me just a moment.
Oh, I found him.
703. Yep.
Okay. All right. I will put you in a breakout room. Give me 1 second. Morning, Catherine. How can I help you?
Good morning, Mr. Peña. We don't have confirmation. We sent out the information, but we didn't get confirmation. So he's not present. I did confer though.
Okay. I think he did show up.
I hope so.
Because I have him marked off as here now. So I don't know if he's in the courtroom or if he's on Zoom, but I know he was here. Okay, so what do we want to do, Miss Catherine?
Well, let me get a reset, please, so that I can talk to him, because yeah, I'm not
He
seeing
was in
him.
the courtroom, but I don't see him in here, but he was in here.
He was, right? Okay.
Yes, but I don't see him in here anymore.
Okay. Okay, so what are we gonna do, Miss Catherine?
Can we get 30 days on him, please?
Okay, and what are we doing? Are we gonna set it for a plea, or what are we gonna do? Missing discovery, what?
Well, I don't believe we're missing discovery. I need to discuss it with them. I guess discovery on my part, because there could be something else coming down or something else out there based on what I read in the report.
Okay, August 30th.
Okay.
Okay.
That's great.
All
Thank
right.
you.
You're welcome. Bye. All right, Paul.
Yep, I just spoke with the prosecutor. He says they just uploaded some new discovery on Friday, so I need time to obtain that.
Okay, how much time do you need? Video uploaded.
Can we do, he said it uploaded Friday, so it takes about 30 days should be fine.
August 30th.
August 30th?
Uh-huh.
Okay, thank you.
You're welcome. Mr. Hunt, how can I help you?
I would just ask for a reset for additional discovery.
Okay, let me just get your case. Hold on here.
It is on page 5,
Okay. Okay, found you.
685019.
Okay, and we're resetting due to what?
Blood test results.
Blood test results. 30 days, 45 days.
30 should be fine.
You should be fine. Okay.
Second setting, so they should be in soon.
Okay, August 30th, sir.
Perfect. Thank you.
You're welcome. Yes, Mr. Nichols, how can I help you? Mr. Nichols?
Oh, yes, ma'am. I'm sorry. I didn't understand. Yeah, the felony is pending. You know, he's got another case of criminal mischief that's in County Court 9.
Okay.
I wonder if we,
I can possibly ask for this one to get transferred to us, I guess.
yeah, I was thinking maybe we'd bring it over here.
Sure, we can do that.
Yeah. And the felony hasn't been indicted yet. It's still pending. I just checked on it.
Okay, so felony pending.
Yes, ma'am. It's all out of the same transaction, same date.
Okay, I will give you September 27th. And in the meantime, I'll see about getting that case transferred to us.
Thank you so much.
You're welcome.
May we be excused, Your Honor?
He is not on, but you are excused.
No, he's here.
He's on. He's on, but he stepped away probably.
Oh, because he told me he was. He said he was in the waiting room.
No, he's on. He just stepped away from his desk.
Okay.
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 Ms. Carrillo, how can I help you?
Here.
Oh, yes. I'll confer with the state. I told him there's a felony pending on this case, so we'd like to reset to see how the felony is proceeding.
Okay, I will do felony unindicted. How about September 27th?
September 27th.
Yes.
Okay, are we free to leave now?
Yes, ma'am.
All right, Mr. Habdi? All right.
I'm right here.
Okay, we can leave now.
All right, thank you.
Thank you. Thank you, Ms. Linda.
You're welcome. I'll be right with you. Yes, Mr. Jones.
Hold on. Yeah, I was looking for the email address of the prosecutor.
Oh, it'll be Kenneth.Delco, DELCO.
Hold on a second. Do you have it, my dear?
It's Kenneth.Delco
Kenneth.Delco
at bear.org.
at bear.org. Kenneth.Delco at bear.org.
Yes, sir.
Thank you.
You're welcome. Yes, Mr. Cerna.
Yes, I'd like to confer if that's possible.
Okay, let me put you in a breakout room.
Thank you.
community service hours, the BIP.
Linda, may I have a breakout room with my client, Matthew Cruz, please?
Sure, give me 1 second.
Sure.
So go back to 12, Elizabeth, and I'll put Matthew Cruz in there with you.
Thank you.
Uh-huh.
Linda,
Yes.
on Mr. Matthew Cruz. The state has agreed to dismiss that case.
Okay, so dismissal should be coming. All righty. All
Thank you
right.
very-
Thank you. Bye-bye.
Bye.
Hey, Brenda.
Hello.
So I had Esteval Rosales. I don't know where he's at. He was on, but I don't know where he went, but he did appear today and he was on yesterday's. And as for today, I don't, hold on, because I think I have you on one. Hold on. Yeah, he was in the courtroom, but I don't show a date for him. Christopher Perez.
Right.
But he's on Zoom, I think.
It's a weird case because when I was appointed, it gave it a CM number and it had my name as attorney of record and his name and the cause number but it didn't give a court number.
I don't
So-
think it was assigned yet, but now it is. So the
Okay,
case number is 688-960.
okay. And so,
I don't show a court date for it. It's weird, but
right,
and it still shows him in jail, but he's not. I think it's a glitch.
right. That's another, it's a weird, something's going on.
Weird. Yeah. So let me go ahead and reset it for you. Is 30 days good for you?
Yes,
When are you coming back here? Do you remember?
to 5?
Yeah.
I don't know. I feel like I'm there every day.
I know I reset you yesterday. Was it the 29th by chance?
Let me look on my calendar. Hold on.
Because I'd like to get all your cases on the same date if possible.
Let's see. Today, tomorrow, Sunday, Tuesday. I show something August 9th, or maybe I don't know. And then also something August 22nd.
You want to do the 22nd?
That's fine.
Okay, we'll do the 22nd. Okay. And then what about on Rosales, the same day?
Sure.
Okay, we'll do both of them for August the 22nd.
Okay,
Okay? And you can let them know, okay?
I will.
All
Thank
right.
you.
You're welcome.
Hello?
Yes?
That was the one that I was talking about, Christopher Perez.
Yes.
Can I be free to leave too, or would I?
Yes,
still-
if you're Christopher Bettis and Brenda Livingston is your attorney, we reset it to August 22nd. So that's when you'll need to appear on Zoom.
Okay, August 22nd, right?
Yes. Uh-huh.
Okay, thank you.
You're welcome.
Bye-bye.
Bye-bye.
Yes. Yeah, I'm still on the Zoom call. Can you tell him I'm on a Zoom? Oh, yeah, I'll call.
Linda, how we doing?
Good morning, Judge.
Morning. Cesar.
Yes, sir.
What you got?
Judge, I had a chance to confer with Mr. Delco, and we're asking for another pretrial. Mr. Delco is going to be reviewing the cases and then get back to us.
What's your case number?
I've got two cases. It's two cases, Judge. 682, 329, and 327. It's a DWI and a UCW.
Frederick Munoz.
Yes, sir.
I'm sorry, what is it you want?
Judge, if we can have a 30-day pretrial.
All right. Linda?
August 30th.
Reset.
That's
30
fine.
days.
That's fine, Judge. I appreciate it.
Mhm.
Can we be excused, Judge?
Yes, sir. Of course.
Oh,
take care.
Thank you, Judge. Take care. Frederick, I'll call you.
Yes, sir. Thank you.
Did Ms. Carrillo get to confer, Linda?
Yes, sir, she did.
Linda?
Yes, Judge.
When you have a chance, for the 28th, we have 500,563. If I remember correctly, I'm supposed to do something on that. Will you pull the file and check it out?
Okay, all right.
Hello.
Zavala.
Yes.
What can
I
I
just
do?
want to. I just want to know my lawyer's name.
Do you happen to know your case number?
No, sir.
Let me look for it. Your lawyer is Gil Calderona.
Okay. Thank you. Is there a?
Have you never met her?
No, no, sir. And is there any time I should be back, or just stay on the Zoom call?
Well, stick around. Let me see what we can do.
Yes, sir. Thank you.
Mr. Zavala.
Yes, sir.
Okay, I got a hold of your attorney. She is in a felony court on a plea, but as soon as she gets through, she'll join us.
Okay, yes, sir.
Right.
Is she gonna call me or?
Just stick around.
Okay, yes, sir.
Thank you.
Hey, Linda, can you put me in a breakout room with with Jessica Gonzalez, please? Because if this is the case, I think it is. Yeah. Actually, I'll just come downstairs.
Did you want me to put you in the breakout room?
If I can see her in your office, I think she's in the courtroom. I just want to be sure that this is the one.
Okay,
Yeah, I think she's in the area outside your office.
actually, I think she's in the courtroom.
Oh, she's in the courtroom?
I think so. If
Okay.
not, you can come back here.
Okay. Where is the?
Linda,
Yes, Judge.
you got anything, any pleas or anything ready?
We will in a minute. I'm just waiting on Kenny on this one for Jessica. And then we'll be ready since she's in the courtroom.
Okie dokie.
Okay, all right.
Is there any way I can be placed in a breakout room?
I'm sorry, Jeannie. Hold on, okay?
Okay, put Mr. Mendez and I in a breakout room.
Okay, Nathan Mendez, right?
Yes, yes.
Okay, sorry.
Thank you, honey.
Cupid,
Morning, Your Honor.
how are you?
I'm doing well. How are you?
Okie dokie. How are the new twins coming along?
They're doing fine. And they'll be joining us in a month or so.
1 month, huh?
Yep, I'm ready.
Wow. Boy, you're gonna have your hands full then.
I know. So
Looking forward
I'm going to
it, huh?
confer with my client, judge, and then I'll come back into the main courtroom.
Sure.
All right, thank you.
Judge, we're ready on the plea. They're in the courtroom ready.
All right, who do we have that's, we're gonna do a plea on, Linda?
It's gonna be 684-385.
Hold on, 684-385,
Yes, sir.
the defendant,
Lauren Reyes,
LAU or LOR?
LAUREN.
What is the charge?
DWI second,
And the defense attorney?
Jessica Gonzalez.
Judge, this is your bailiff. I just want to make sure you can hear us loud and clear.
I can hear you very clearly, thank you.
You're welcome, Judge.
Is that the only plea?
Yes.
Wow.
And Judge, just for the record, this, I know it's listed as a DWI second, but it was actually charged incorrectly. So it's really,
Ken, I'm having trouble hearing you.
can you hear me now, Judge?
Yes, sir.
Okay, so it's charged as a DWI second, but it was originally charged incorrectly. It's not supposed to have ever been a DWI second.
So it's a DWI first?
Yes, sir, but the information reads as a DWI second.
And actually, Your Honor, I believe a couple of months ago, it was on May 10th, the district attorney's office did file an amendment to amend it to a DWI first.
Very good. All right. At this time, Kayleen, you ready?
Yes, sir.
Okay. At this time, the court calls case number 684-385, State of Texas versus Lauren Reyes. Are you Lauren Reyes?
Yes, sir.
Raise your right hand, please. You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. You may put your hand down. Lauren Reyes, you've been charged with DWI first. At least it was originally DWI. I don't know whether it was originally DWI second or just there was a mistake, whatever. Is
Your
that
Honor,
now, is that amendment now, was it already accepted or was it submitted just without approval by the court?
Your Honor, it should have been actually, I received it as a submitted and I assumed that it was actually accepted. My client, when she was booked, they incorrectly put on a previous conviction. So that's why they charged it as a DWI second. However, when I reviewed the NCIC, TCIC and court with the state, we discovered it was a different Lauren Reyes. So my client has never had a prior conviction for DWI.
Okay, so now my question though, do we have to do the amendment process here and now, or has it already been done? And just that, has it already been done?
That would be up for the state. I don't know if they had it signed by the court. I just received it as an email through e-file that it was
Okay.
filed.
For the record then, does the state have a motion to amend in case this thing is still on the record as a DWI second?
Judge, the state has filed a written amendment. So it's gonna be a DWI first at this point.
All right. Defense, any objection to the amendment?
No objections, Your Honor.
There being no objection, then officially I approve the amendment to DWI misdemeanor B. Now, are you Lauren Reyes that was originally arrested and charged with DWI?
Yes, sir.
Okay. You are under oath, so before we proceed with this hearing and your plea, I am informed, obviously, that you have worked out, with the help of a very able attorney, you've worked out a plea agreement. Before we go forward, I need you to know and be aware that you have certain constitutional rights and protections. One is the right to remain silent. That means you do not have to make any statements. You do not have to answer questions. You do not have to submit written papers that have your signature, especially papers that admit or confess to wrongdoing. That is the right to remain silent. Do you understand that?
Yes, sir.
You have the right to a jury trial. That means you and your attorney, working with the state's attorney, could select 6 citizens that are disinterested in your case, and from a pool of jury, rather from a pool of citizens. Those 6 selected would have the duty to see and hear any evidence and decide whether you're not guilty or whether you've been proven guilty beyond reasonable doubt. You understand that?
Yes, sir.
You have the right of confrontation. That means that if you decide to go to trial, you and your attorney could question, cross-examine, or challenge any witness that would testify. Is that clear?
Yes, sir.
You also have the right to appeal. Once this is all over, you yourself, your attorney herself, or the 2 of you together would have the right to demand that a higher court review the official record and the evidence in this hearing for whatever legal challenge you wanted to make. That right is an important right, but I also caution you that it is difficult to carry it out because you have specific and clear time limitations and requirements of documentation and information. The official record being prepared by a certified court reporter, Ms. Kayleen Rivera. Do you understand you have the right of appeal?
Yes, sir.
Now, I further inform you that as part of this plea bargain, if you in fact do enter a plea and I accept it, then you will, as part of the agreement, you give up the right to appeal. There's a document titled Trial Court Certification of Defendant's Right of Appeal. There in that document, I have informed you of that, and you have reviewed it and signed that. Is that correct?
Yes, sir.
Now, there's several other documents that you have signed, reviewed and signed. Before you signed them, did you review them with your attorney?
Yes.
Did you understand the documents you signed?
Yes, sir.
And do you have any questions concerning any documents you signed?
No, sir.
Now, there's another critically important document titled Defendant's Waiver of Constitutional Rights and Court's Admonitions. That document, like all the documents that you've signed, identifies you by name, case number, and court number. The particular document, among other things, it establishes in writing your rights and protections that I have talked to you about verbally, and it establishes that you know and understand that you have those rights. Did you see and understand that as part of this document?
Yes, sir.
Another thing it tells you is it establishes what you're pleading, what you're pleading to, and what your plea is. And in addition, it explains to you the range of punishment for the offense to which you are pleading. Did you see and understand that as part of this document?
Yes, sir.
This particular document also tells you that any deal that you've made with the state is not binding on this court. The deal has to be reviewed by me, and if I accept it, you have a deal. If I reject it, you do not have a deal. I also have the authority and responsibility to establish what your punishment will be for whatever plea you enter. That punishment has to be within the range of punishment for your offense. And it also, I also inform you that if I give you any punishment that is in any way heavier or greater than what you've agreed to, then in that case, you'd have the right to start all over again, including if I reject your deal, you have the right to start all over again. And nothing that you've said or signed up till now would be used against you if under those circumstances you started again. Do you understand that that is told to you in that document?
Yes, sir.
Do you have any questions about the defendant's waiver of constitutional rights and protections?
No, sir.
All right. So, Mr. Delco, does the state have any further motions?
Yes, Judge, the state is going to abandon count one of the DWI first and proceed on obstruction of a highway passageway or roadway due to intoxication.
All right, and that makes it a Class B.
Yes, sir.
Any objection, Ms. Gonzalez?
No objections.
All right. And Ms. Reyes, what that means is your attorney has gotten this reduced from DWI to obstruction, which is obviously beneficial, and I'm sure with that will be a deferred recommendation. Is that correct, State and Defense?
Yes, Judge, it'll be a deferred adjudication.
Yes, Your
All
Honor.
right. So, Ms. Reyes, to the charge of obstruction of a passageway, highway, or waterway, how do you plead?
Guilty.
Did anyone threaten you or intimidate you or promise you anything other than the plea agreement in exchange for your plea of guilty?
No.
Are you pleading guilty because you believe you are guilty?
Yes.
All right. Also, you have applied for probation. Did you understand what the document told you?
Yes.
You'd signed that document. I further inform you and clarify for you that deferred adjudication is a special, very beneficial form of probation. Your part of it is that you will live up to 100% of the conditions of supervision. If you do that, then you will have your case will be dismissed, and you will not have a record of guilt or conviction for the charge of obstruction. If you fail or refuse to live up to 100% of the conditions, and the state may ask me to give you official notice, bring you in for a hearing. And in that hearing, if I believe the evidence is sufficient or the circumstances merit, then I will convict you at that point. The conviction will follow you the rest of your life, and I will have the full range of punishment to consider for punishment. That is a fine from $0 to $2,000 and jail from 0 days to 180 days. Is that clear, ma'am?
Yes, sir.
All right. So I find that there is sufficient evidence to find you guilty, but I do not find you guilty. Instead, we're going to grant you deferred adjudication. Mr. Delco, would you recite into the record the recommendation that you and the defense are in agreement on?
The state had recommended $500 fine plus court costs, 14 months of deferred adjudication, DWI education, victim impact panel, a TAP evaluation, Smart Start Mobile for 1/2 the term, and 60 hours of community service restitution. That's 6-0, Judge.
6-0.
Yes, sir.
Ms. Gonzalez, is this your understanding of the agreement?
No, Your Honor.
I'm sorry?
I said no, Your Honor.
Well, tell me what you believe the recommendation is.
Your Honor, it was supposed to be for half the term with ignition interlock. That was our agreement. And
That's
then
7
I also,
months.
I'm sorry,
That's 7 months.
that's 7 months. So half the term of 14 months. So 7 months of ignition interlock. But then I also needed to approach specifically about that, Your Honor.
Okay. So she does have an ignition, she does have or will have an ignition interlock on her vehicle.
Yes, Your Honor. So what's going on with her vehicle is because she was originally charged incorrectly with a DWI second, she had to have ignition interlock installed on her vehicle as a condition of her bond. She's had it on her vehicle since the time of her arrest. However, her car is in need of repair. When we approached at the last setting, I actually spoke with the visiting judge at that time, and we got a court order from the visiting judge to allow for the ignition interlock removal temporarily so that the vehicle can be sent to the manufacturer for the repairs that needed to be done. And my client submitted that court order with a notarized affidavit of non-driving to probation, not probation, to pretrial services, who refused to accept the court order.
No kidding. Okay. So
So
what was the date of arrest?
the date of arrest, if you can give me one moment to pull up the police report, Your Honor.
Linda, you can tell me from the records.
Yes, May 5th, 2022.
So from that date, she was placed on ignition interlock.
That is correct.
Okay. So why is there an agreement for ignition interlock of any kind?
That's just my understanding of a standard obstruction agreement. And just so the court knows, my client understands ignition interlock, and she's willing to have it on her vehicle. She just needs the either, I guess now probation, since she's taking the plea, to be able to accept the court order that it be removed temporarily while the vehicle is being repaired, and then she will have it put on there, and then also accept the affidavit of non-driving, which she's sworn to the court she's not going to drive a vehicle until she gets her vehicle back and has ignition interlock installed on her vehicle.
How long will this take? Ms. Reyes, how long is it going to take to get your vehicle repaired?
It has something to do with the engine. They have to take it to the Ford manufacturer. So I have no idea. They didn't give me an estimated time because it hasn't been to the shop yet.
That's interesting. How is that, a brand new vehicle or what?
Sadly, yes, it is.
Well, and Judge, what's actually interesting even more is my client showed me the email that she got from pretrial services, and pretrial services was originally requesting a court order for the judge to give to them the, what was it called? Bypass code. So she could bypass ignition interlock, which we thought was wholly improper. I spoke to the state about it at the last setting, and this is the agreement that we came to, was just going ahead and removing the device temporarily so they can work on it, and then she was going to have it installed back on the vehicle. But like I said, we were hoping to have it done before this plea, and pretrial services refused to accept the documentation that Lauren provided to them.
All righty.
And I mean, if the court wants to and the state wants to, she can do Smart Start Mobile, but I know the court's not going to be happy once she gets the vehicle back in her possession if she has access to a vehicle without ignition interlock.
Well, why don't we go ahead and put her on Smart Start pending the return of the vehicle? And the order will be, Ms. Reyes, for you to get this thing done as quickly as possible. Once you've gotten your vehicle back, I'll want the ignition interlock installed on it for a total of 7 months of ignition interlock and Smart Start combined.
She'll have to pay for 2 devices?
No. One replaces the other. When she gets the car back, we take off the ignition interlock and, we take, we put in the ignition interlock and immediately remove the condition of Smart Start.
Okay, I just wanted to make sure it would just be one at a time.
Yeah, it'll be one at a time.
Okay, thank you, Judge.
But meantime, I want her monitored in accordance with the agreement. Now, Ms. Reyes, do you have children you support?
No.
All right. And what is your total income monthly?
Approximately. Like 3,000.
You say that like you're asking me. I don't know.
Well, it's because I just started a second job, so I'm not too quite sure.
You say 2 jobs you're going to have, or is it a different job?
It's 2 jobs now.
So what is the total income is 3,000? The combination?
Yes, sir.
All right. Let me. So you're getting about 1732, 10162 per hour. Alrighty. We'll make the supervisory fee will be $34 a month. So you have pled guilty. I grant you the deferred adjudication in accordance with the agreement as recited into the record. Well, let me back up. Ms. Gonzalez, other than the discussion we just had, is the rest of this agreement what you are and the state are recommending?
Yes, Your Honor.
All right, then just to clarify, there will be 7 months of monitoring on the vehicle or a combination of Smart Start Mobile. As soon as you get your vehicle back, we will have the ignition interlock installed and immediately remove the Smart Start as a condition for a total of 7 months combined. Anything further, Ms. Gonzalez, please have your client place the thumbprint on the documents as required by law. And then she will meet with Maricela Luna so that Ms. Luna, the court liaison officer, can get her started on probation. Ms. Reyes, when you report to probation, they're going to read to you the conditions of supervision that you're required to live up to 100%. You will sign those conditions and they'll put a copy in your hands and you'll know exactly what you may do and exactly what you must not do. Is that clear?
Yes, sir.
Part of that obviously is no drinking any alcohol for the next 14 months. All right, then this concludes this particular hearing. Any questions, Ms. Gonzalez?
Yes, Your Honor. Will probation need a new order to have the ignition interlock removed? Like I said, we got it back and I have a copy of it in my records. I got it a couple of weeks ago, but pretrial services was refusing to honor it. So she still has ignition interlock on the vehicle and she needs to get that off so she can have it sent out for the repairs.
We'll make sure that they get a copy. Ms. Flores, make sure that, well, actually, well, probation will certainly obey my order. You're talking about pretrial. They were, for whatever the reason, they chose not to. That's inappropriate, but I don't know what their thinking was. Anyway.
Okay, thank you, Judge.
You're welcome. Anything further? State, defense? Very good. Thank you. Then you're, pardon me?
Judge, sorry, I didn't mean to interrupt. I believe Ms. Gonzalez had one other matter she wanted to approach the bench on with the state.
On this particular case?
No, sir, not this case.
Okay, Ms. Gonzalez.
Yeah, no, Your Honor, I need to take care of and get Ms. Reyes over to probation. And then I told Linda that I would wait for you to handle the rest of the docket matters.
Already.
Or until there was a break in the docket matters, but it will need to go on the record.
What? You lost me now.
I'm sorry, Judge. I do have a matter on the docket that I need to approach on and we need to go on the record on it.
I got you. Yeah, that's a different case.
A different case, but I told Linda that I would let you finish the rest of the docket so we weren't holding up the docket.
Okay, well, I appreciate you letting me finish the docket.
Yes, Your Honor.
All right, thank you. We'll get right back to you. Ms. Calderola. You're muted.
Good morning, Your Honor.
Good morning. How you
I
doing?
apologize for being late. I was
All right, I know you were busy.
okay. I have a Sway Zavala, and I need to confer with a prosecutor, and then I need to speak with my client.
All right, you go ahead and confer with the state.
Your Honor, can I be excused to go back up? Sorry, can I be excused to go back up to my office to confer with Ms.
Who's going to confer with Ms. Calderola?
Yes, sir. Yeah, I'm going to, but I was asking if I could please be excused to go return to my office to do that.
Do what you gotta do.
Thank you.
Do what you gotta do, of course.
Yeah, once he gets back into his office, I'll put you in a breakout room.
Okay, that sounds great. Thank you.
How you been doing?
Oh, okay. Just busy, you know?
That's good.
Yeah.
How's the rest of your family, everybody doing?
How are you? How are you? Yeah, well, it's going to be a year for my mom, you know?
Yeah. Well, my mom on the 16th turned 100 years of age.
Oh, my goodness.
Yeah.
What are you going to do for her?
Yeah. All righty, kiddo.
Okay, thanks. I'll just wait here.
Anybody else need to approach?
Judge, this is your bailiff.
Yes, ma'am.
On page 3, Judge,
Yes.
case number 677-744. Braxton Anita.
Yes.
She walked in at 11:05, but she stated to me that she had been on the first floor the whole time. She did see people sitting out there, but she found out they were potential jurors. So she found out otherwise, and she walked into the courtroom. And she also notified me that she has a court-appointed attorney, Oscar Hernandez,
Okay.
but she is present in the courtroom, Judge.
Okay. Ms. Braxton,
Yes, sir.
why don't you approach the bench?
Yes, sir.
So you were sitting downstairs on the first floor?
Yes, sir. I previously saw Judge Castro on the 6th of the month, and we were rescheduled for today. And so I showed up there, I gave my name, and they put me in the hallway with a lot of people. And then in discussing with the man next to me, he told me he was there for jury duty. And that's what
Well, haven't you been here in court at least 3 times before?
not up here. No, sir. I've been downstairs, always on the first floor with Judge Castro.
Okay, is this a county court 2 transfer, Linda?
Let me check. 1 moment, Judge.
677744.
Your Honor, I was supposed to be being referred to Veterans Court, and I was turning in my VA paperwork today, my proof of veteran service.
Okay, well, hold on a little bit.
Yes,
All
sir.
right,
No, Judge, it's been in our court, but she was just released on June the 25th. That meant she was picked up on a warrant.
all right. Now, you know where you're at now, right?
Yes, sir.
And did Mr. Hernandez, was he coming in or not?
I have no idea, sir. I assumed he was because he told me to be here at court today. And I
All
went.
right, well, from now on, you make sure you're here at 9 o'clock in this courtroom, or on the, if we're doing it by Zoom, you make sure you're available at 9 o'clock. You understand?
Yes, sir.
Judge, I don't show an attorney for our case, for the misdemeanor case.
She says she's got Oscar Hernandez was appointed, so double check that.
Oscar Hernandez is on the felony cases, not the misdemeanor cases.
Okay,
I believe they all go together, sir.
okay. What's going on is you have 2 felony cases, ma'am, that are pending, and this one is a misdemeanor case.
Yes,
So, have a seat. Linda, visit with her about appointment of an attorney for this case.
Okay.
Jeannie Cupid, what you got?
I'm back, Your Honor. I am presenting some evidence to the state via email for consideration in resolving the case with Mr. Mendez. I've obtained a reset date already, and so I would ask for 1 reset while the state and I continue to confer about the status of this case. This is our first setting, Judge, and so I think 1 reset would be appropriate. So we would just ask to be dismissed, as Linda has already given us a date of the 30th of August.
Very good. It's refreshing to have somebody that's moving their cases. I've had as many as 26 resets on one case. So,
That's not
yeah.
cool.
Yeah, tell me about it. Okay.
All right,
All right.
Judge, I will be diligent in getting this moved along one way or the other. So may Mr. Mendez and I be excused?
Of course you may. Thank you.
All right.
Good to see you.
Good to see you, Judge.
Give my
I'll see you
regards to
soon.
David and
I will.
a little pat on the wherever for
Yeah.
Ezra and Elliot.
Yeah, well, they're reigning terror, just so you know.
Oh, that's great. They're supposed to, especially
Yeah,
when
well,
they're
they
good.
are. So, all right, Judge, thanks so much.
You're welcome. Good
All
to
right,
see you.
take care. You too. Bye-bye. Thanks, Linda.
And I see the late Raimundo Aleman.
I was in court. I was in court in person. They
Did you let
finally,
us know?
yes, I called and I told my client to let you know that I'd be here. But I have a problem with this client that he has a felony pending out of the same thing, which is going to the 144th. And he seems to think that he can resolve everything today and tomorrow. And I told him, no, you cannot do that. You have to handle the felony first. And you have to wait.
Ordinarily, but there are occasions where we can do the misdemeanors. So, have you talked to the state concerning Mr. Blaine?
No, Judge, we only got this case about a week ago.
Okay, well, it's a new case and there's not even a file, so.
I have told him that. He thinks he can just dispose of everything. I said, you cannot dispose of it until you're indicted. And he said, no, I don't want to be indicted. I'll just go over there.
Well, I guess he gets to call the shots, huh?
And I told him that that's not what
We'll let
happens
him, if he
in this
doesn't
court.
appear, Raimundo,
No,
if he doesn't report within 1 week, he can call the shots from the jail.
No, he told me there that I sent him the Zoom and he got it.
He did appear in courtroom, Judge.
Okay.
Yes, and I reset it, Judge, because it's a no file too.
What time did he appear?
9:55, Judge.
What time?
9:55.
Okay, is he already gone?
Yes, sir.
Okay.
So when did you reset him for there?
September 27th, because it's a no file.
Yes, and September 27th. Yes, he just seems to think that he can just get rid of this case in 1 week.
All right.
But he has
Thank
two
you,
cases.
Raimundo.
All right, Judge, my big excuse.
Yes, sir. You take care. You got your date.
Thank you, Judge.
We got anything left, Linda, except for this afternoon?
We're waiting on Gail Caldelora.
Okay.
And then Jessica needs to talk to you.
I'm sorry?
Jessica Gonzalez will talk to you
Yes.
after we
Okay.
are done with Gail.
All righty.
Okay, Mr. Rodriguez, Eric? Unmute yourself. Unmute yourself.
You're muted, Mr. Rodriguez. There you go.
Okay. Hello?
Eric Rodriguez. Speak up. Okay, it looks like you've got a technical problem. We can't hear you. All right, when everybody unravels, I'll take a.
Judge, Mr. Rodriguez, he's on page 4, 683475. He has 2 felonies that are, well, he has, 2 felonies that are unindicted.
Okay.
And
Let's give him the felony pending 60-day reset.
okay, I will let him know. Thank you. Okay, Mr. Rodriguez? I'm gonna reset your case to September 27th. Okay, and I need you on Zoom that morning, okay? And I will let Dylan George know as well. Okay, all right.
Where's Jessica?
Jessica's back here with her client, and then as soon as we're done with Gail, I'm gonna let her know to go back into the courtroom, so once we are done with Gail, she can talk to you.
Well, we can probably deal with Jessica right now.
Judge, can you hear me?
Yes, ma'am, I sure can, very clearly.
Okay, is Kenny back?
Do me a favor, move a little to your right. Right there, perfect. Now step back. Perfect, all right. I
Is Kenny back?
thought you had already talked to him, I'm sorry.
I have spoken with him. However, what I need to put on the record will require him to make an announcement, and I would prefer to have him here while I explain everything.
Of course.
to the court.
All right, which case are we talking about?
We're talking about Misty Menard. And if you
Case
give me a
number.
minute, 1 second. 610020.
Oh, okay, way up at the top.
Yes, Your Honor. It's a very old case.
All right, well, we'll have to wait till he's available. He had gone back up to his office, but he was conferring.
Right. I can wait for him.
All righty,
Thank you, Judge.
you're welcome, dear.
Okay, Judge, I'm sorry, I'm back.
No problem. Ms. Gonzalez was waiting. She wants to put something on the record. Ms. Gonzalez, which case are you referring to?
Yes, Your Honor, Misty Menard. If you give
All
me
right.
one moment, it's 610020.
That's correct. She was listed as a fugitive, but she did appear.
No, Your Honor. You have her as appearing?
Well, it's listed as a fugitive. Is there a warrant on her, Ms. Grabowski?
Judge, I do also have her listed as a fugitive. As the warrant, I have not ran it. If you'd like for me to run it and check, Judge.
Yeah, you might double check it, but meantime, Ms. Gonzalez,
There is a
Yes.
warrant.
and that is from what, do you know?
It's on 610020, and it's a bond increase warrant. I will check and see why we issued it. Failure to appear on July 30th, 2021.
Ooh. She's had a warrant for a year.
Yes, sir.
I'm exaggerating. 11 months and
26 days,
23 days,
23 days.
something like that. Anyway, what you got, Jessica? Let's talk about that and we'll handle the warrant.
Yes, Your Honor. So I filed on June 8th.
Judge, do you want me to go on the record?
Yes, ma'am. Court
Okay.
calls case number 610020, State versus Misty Menard, Menard. Alrighty. Ms. Gonzalez.
Yes, Your Honor. On June 8th, 2022, I filed a motion to dismiss for lack of due diligence and violation of right to speedy trial. I'd been trying to confer with the prosecutors since before I'd filed that motion to dismiss. They were unable to provide any of the answers to me on how they were going to proceed on the case. So that's why I filed this motion that's before the court. I did e-file it, so it was served to the district attorney's office on that day. So they've had notice of this motion for over a month now.
And this is from June the 8th of 22.
Correct, Your Honor.
Now, does the fact that the lady failed to appear back in July and has had a warrant on her since then, July of 21, does that, you might need to consider that in your motion or at least be aware of it?
Yes, Your Honor. So I have two responses to that, which is one, my client, the reason that she failed to appear was because she was in state custody. She's actually in TDC as we speak right now.
Oh,
So with her being in TDC, even if she failed to appear to court under the case law for speedy trial, the burden is still on the state of Texas to be able to show that the delay is reasonable. And as the court correctly recited on the record, or before we got on the record, that she's had this warrant for the bond increase since July 30th of 2021. It is my proposition that the
Judge,
state.
I'm sorry, Jessica, I'm sorry. I don't mean to interrupt, but Judge, it sounds like we're going into a speedy trial motion and the state was not prepared to give a response. The court's also going to hear no testimony today. So we're going to ask for either a proper 3-day notice to get a date on the docket for this type of hearing, because it's fundamentally changing the proceeding.
And Your Honor, that's why I put on the record to start off that I did serve the state with this motion on June 8th of 2022. So if the state is taking a not ready, I
The
would
state's
like
not
that.
taking a not ready. It's that we did not have a date
It's on the
assigned to
docket
us.
today.
well,
Not
in
as a speedy
fairness,
trial.
fairness is a two-way street in this matter. This docket does not show a motion for speedy trial setting. It is strictly a pre-trial setting.
Correct, Your Honor.
Now, we will give you a hearing date for a motion on speedy trial if you're ready to proceed on that. Linda, how long would it take to bench warrant this lady? Where is she at? Do you know, Jessica?
She is somewhere outside of Houston, Texas. And Your Honor, that's exactly what I'm trying to avoid, is that is going to create exceptional costs for the state of Texas and a danger to the state of Texas in transporting a person back to Bexar County when her rights have already been violated.
Judge, again, there's gonna be no testimony without her witness. So the
Okay.
court can't make an informed decision.
Okay, so
But
you
this
wish to
testimony-
present your, Ms. Gonzalez, you wish to present your motion for speedy trial violation, not for it, but alleging violation of speedy trial, and the state is not ready to address that right now, this moment. So, Linda,
Yes, Judge.
approximately how much time would it take to get the lady bench warranted down here for a hearing? Is she actually in jail? Because I showed her answering on this matter. Is she's in custody, you say, Jessica?
Yes, Your Honor. I received a call from her as late as July 20th of this year, so about a week ago. And then I also spoke with a family member of hers a couple of days ago who confirmed with me that she is still in custody. And because of this warrant hold, she was not able to make parole. So it's my understanding she is still in custody. And as far as any evidence that the court would need for speedy trial, that is actually provided for in the court's record as the court just recited.
Linda,
Yes, sir.
I have her having answered. Am I incorrect? Did I just presume she was here, or somebody told me she was here, or what?
No, she's not here, Judge.
She did not answer, Judge.
Okay. All right. So as of right now, what'll it take? 2 weeks or a month, Linda, to get her here?
I could do August 22nd. That will give us enough time to do the bench warrant.
Okay, we'll give that priority so we can issue a bench warrant. And Ms. Gonzalez will give you August 22nd to be a hearing on the violation of speedy trial, allegedly. And Mr. Delco, you will have that date. Okay?
Thank you, Judge.
All
I
right,
just want
guys.
to make sure it's on the record that he was not ready for the speedy trial.
It wasn't a not ready, we did not have a date.
I am not finding that the state is not ready on the speedy trial motion. There was no setting on that, Ms. Gonzalez.
Thank you,
And,
Judge.
Obviously, it will be something for you to take in consideration on delay. And that's on the court, not on the state. So, although they wind up being one and the same. All righty. August 22nd,
Yes, sir.
Ms. Flores issue the bench warrant.
Yes.
Find out where she's at first.
Okay, and I will issue it and it'll be set at 2 o'clock.
All righty. Okay, Ms. Calderola. Thank you, Ms. Gonzalez.
Thank you, Judge. May I be excused?
Yes, ma'am.
Thank you, Judge.
Yes, Your Honor. I'm here on Sway Zavala. I've conferred with the state and he's going to get me the specific offer by email today or before the end of the week. I just got this case a few weeks ago and I don't have all the discovery yet, and he's going to get me an offer.
Okie dokie.
All right.
30 days.
Yeah, that sounds great.
Okie dokie. Now, I don't mean for you to do 30 days, but to reset it 30 days.
August 30th.
Alrighty.
Okay, thank you, Linda.
You're welcome.
Hey,
All right.
Judge.
Yes.
So does that mean I could get out the Zoom call?
Sorry.
Does that mean I could get out of out of the Zoom
Oh, is that
call?
my client?
Yes.
I need to talk to him.
Okay, hold
I
on.
didn't know, I didn't know he was
Put him-
still there.
Linda, can you put them in breakout?
Yes. Gail, go back to room 7 and I will put him in there with you.
Okay, great. I'll do it.
All right. Todd Overstreet, what's going on?
Yes, sir. How are you, Judge? Sorry for the delay. I had court in Giddings, Texas, and I just kind of got released.
Giddings, Texas. Oh, how lucky can you get?
Yeah, exactly.
All right, who you on?
I'm here on Clint Moore. It's a criminal mischief case.
Clint Moore.
681-894, bottom of page 3.
I think I just got a note here from Mr. Delco that he wants me to join in his breakout room. You want me to do that real quick, Judge?
Yes, sir.
Okay.
Mr. Moore, by the way, is he already gone?
Yeah, Mr. Overstreet, yes.
I'm
But
sorry,
Mr. Moore was an FTA, but
he's a no-show, right?
yes.
Okay, okay. Alrighty. We'll relax till, I guess the last one is Overstreet.
Yes.
Okay, dokie. I am here. Man, it's already almost lunch hour, huh?
Yes, it is. And then don't forget, 1 o'clock is Veronica Legreta.
Legareta.
Yes. And then we have Ashley right after.
Right. Oh. Legareta was a speedy trial allegation, right?
Yeah, that's the one from last week that you asked me to reset for today regarding the medical records or something. Remember
Yeah.
what this is? Yeah, it's on that one.
Ms. Grabowski. Deputy Grabowski. Kayleen,
Yes, sir.
I want you to know you got me hooked on that oat and nut bread.
Uh-oh, sorry about that. It's hard to beat.
Okay, what you got, Mr. Overstreet?
Well, I guess like in the military, it's going to be hurry up and wait. When we were there last, we were told that he should apply for PTD. I went down the hall and filled out an application and turned it in. We just haven't, it's been cricket since then. So I was trying to get the DA's office just to let us do all the conditions that were going to be required, which was the online anger management, pay the restitution for the telephone and be done with it. But he's not comfortable with that. So I guess I'm going to have to wait until we get official word from whomever in the PTD division signs off on his application.
Alrighty. So then we'll give you, you did make the application.
I did, yes, sir. I went down there the last time I was here, I think on 5/24.
Which case was it again?
Clint Moore, Clint with a K.
I know, but case number.
681-894.
Oh, yeah, right here at the bottom. No, he did he appear?
I called yesterday. He was traveling today on a plane, and I asked if I could zoom in on his behalf, but he and I talked yesterday and the day before, and I've been in complete contact with him. I actually know him personally. I team rope with him. So it's someone that
what with him?
Team rope, cowboy with him.
Really?
Yes, sir.
All right. Well, I'll take your word for it this time, but next time you better appear.
Yes, sir.
Let's give you a 45-day reset. That should give you enough time to maybe get some of your things done ahead of time, even if it's not by agreement.
Well,
And,
I asked to do that, and he told me not. The DA said don't. I said, can I just at least pay for the complainant's telephone? I mean, and do some of the stuff, and he said no until he didn't feel comfortable with that until we were officially approved. I'm like you. I want to move this thing along.
Who didn't feel comfortable with that?
Judge,
The prosecutor.
and if I could respond to that, so what's going to happen is if we let him do all of this up front when he's accepted to PTD, there's nothing to hold him to. So I would rather him wait to be accepted into the PTD program, because what happens is if he's not successful, our office does usually refile these cases. So we have to have something to hold him to do that, to go through that program. The conditions have already been put on the program. It's just a matter of waiting to hear if and when he's accepted to it.
Well, I'm not so sure that I agree with that, but I'll respect your position. I'm not going to try and change it. Mr. Overstreet, let's go ahead and wait on that, and let's give you 45 days to see where you get. I would invite you, if you're accepted, or your client rather is accepted earlier than the 45 days, contact Ms. Flores, my coordinator, and get an earlier date.
Yes, sir.
All right.
And Judge, once we're off here, I'm going to go follow up with the pretrial diversion department to see the status of this application.
I'm not quite certain I understood what you said, Kenny.
I'm going to go follow up with pretrial diversion after before our 1 o'clock hearing to see where we are, to see if I can get an update for them.
Okay. All right.
And Ms. Flores, will you send me the date, or do you want to pick
I'm
it
going
right
to give
now?
it to you right now, September 20th.
September 20th. Sounds amazing.
Is that your office or your house or what, Mr. Overstreet?
You know, Judge, it's where it's a place where I keep my horses and rope, and it's in between Giddings and Houston, and I didn't want to keep you waiting.
Yeah,
so
but I'm talking about the room that you're in.
No, that's what I'm talking about. It's just a kind of a ranch house office.
Yeah. Nice.
Yes, thank you.
All right.
Okay, appreciate
You
you.
got your date. You're now excused. Go get your lunch.
Thank you. Have a great week. Yes, sir.
Judge.
Yes,
Okay, so back to Misty Menard. I spoke to Linda and she can get us in here for a hearing on August the 1st. It's just that the witness that would come in to testify, I wanted to ask if we can do him remotely over Zoom. So we can all be in person, but his testimony, he would have to log in over Zoom.
I don't have a problem with that. It's a pre-trial hearing. It's not a jury or,
And that way it'll, we don't have to bench warrant Miss Menard back and for the state to bear that cost.
okay,
Okay, so I'll be here. She has me on your calendar, and so that way Delco's on here, so he knows.
August 1st is Monday, isn't it?
Correct, Your Honor, and that's their 3-day notice.
All right,
So
good,
we'll see you guys in the afternoon for that hearing.
good enough.
Kenny, did you get that? I want to make sure you have notice of the hearing.
Kenneth Delco. He done said, I'll catch you later. I'm gonna go eat. Well, he has a chance.
He's on.
Give him notice, Linda.
Yes, Judge.
All righty. We'll see you Monday then, Jessica.
All right, thank you, Judge.
I always say, Dios primero.
You guys take care.
So we are at this time then excused for lunch.
Okay, see y'all in a while.
At 1 o'clock. Bye.
Ms. Luna,
Bye, everybody. Have a good night.
you're muted, Ms. Luna. Maricela, you're muted.
Oh, I'm sorry.
Okay, so what were you saying? I know you were saying all
said-
kinds of nasty things because
No. No, I said, Linda, I need to come back for the 1 o'clock one?
yes, ma'am. Why do you insist on facing away from the court?
What do you mean? Oh,
Yeah.
that's just how it is.
You got your bench, you got your back turned towards me.
I know, Judge.
Nothing wrong with that, but that's okay, you know?
Yeah.
So I got an update on Mr. Moore. So I walked down the hall. So he was accepted and approved into the program. His application should be going out today or tomorrow for sure. Thank you.
All righty, so Mr. Overstreet, would you do me a kindness and get a hold of Overstreet? I'd already excused him. We had given him a date.
Yes, sir.
Thank you, Judge.
Okay, guys, go get your lunch.
Okay.
You know what? I better mute myself.
Yes. Kayleen,
Yes, sir.
where's our 1 o'clock victims?
That's a mighty good question.
Well, I had to wolf down my sandwich in order to get here at 1, and here I am, and nobody else except
Yeah,
Linda and yourself. Of course, I don't even know if Linda's here.
I'm still chewing on my lunch too.
There you go.
I'm
How's
here.
everything going for you? How's Steve doing?
Good, real good. We're all more so blessed. I just can't even imagine.
Yeah,
How about you?
we're okay. I haven't checked my blood count in a couple of weeks, so the doctor wanted me to get a new one, but I have to go all the way across town to do it. And I've got a friend that his wife's a doctor, and she has a medical lab right here, not even a mile away from the house, as the crow flies. So I'm gonna check with him and see if I can go run over there and get that, and then have him send the results to the doctor. Hey, it's Maricela Luna, or at least her forehead. Oh, there she is. She went to lunch and changed her hairstyle.
Who did? I did.
That happens on days when it gets over 100.
Realize almost every day in July has been over 100.
Yeah, and last year we only had a couple days where we got to 100.
Yeah. And what's interesting is that the power has stayed up. The electrical has kept up with it. Okay. We got Mr. Delco. You all set? And Ms. Legareta.
Okay, Judge, can you hear me? Just test.
Who you got there with you, Kenny? Is that Escobar?
It is
Where'd you dig him up?
the 187th.
So you over in the 187th, Daniel?
Yes, sir, Judge. They actually assigned me, sorry I never got to come in and say goodbye, but pretty much told me, what was it, 2 Thursdays ago? Yeah, roughly 2 Thursdays ago that I was gonna be in the 187, so they already started putting me to work.
All right. So are we ready to proceed? Ms. Legareta, you ready?
Yes, Judge, I am.
Daniel and Kenny, y'all ready?
Judge, state's ready to proceed on this matter.
You what?
We're ready. Ready?
Okay. All right, this time court calls case number 654680. State of Texas versus Ulises Campos. And your defendant?
Judge, the court had told me that he did not need to be present, but he is ready to log in via Zoom if you need him.
Okay. Well, obviously you're not going to put him on the stand.
No, Judge, not unless the court would like to hear from him, but he is on standby, ready to log in at 1 minute.
Good enough. All right. So what is your motion?
Judge, I have a motion for a speedy trial. It's been on file since March of 2021. More specifically, March 25th of 2021.
All right.
May I proceed, Judge?
Yes, ma'am.
Judge, this case, the offense date is March 6, 2020. It was filed with the DA's office on June 16th of 2020. They did nothing with this case until January 26th of 2021.
at which point a warrant was issued for my client. He was picked up and released from jail. Immediately within 2 weeks, I filed my motion for a speedy trial along with other discovery motions. We have come to court on April 8th. I'm sure you can see the jacket, the file jacket, Judge. April 8th, May 14th of 2021, 10/12/2021, 10/23 of 21, 12/11 of 21, 12/21, 21, 12/31, 21, 3/25, 22. And most recently, we were here on May 5th of 2022 and June 6th of 2022. Throughout these entire times, I have requested medical records from the state. Now, the case that controls in this issue is going to be Barker v. Wingo, which the court is well aware of. So we have to consider the length of delay, the reason for the delay, the assertion of right, and the delay prejudicing the defense. So the length of the delay we meet, we automatically meet that already, Judge. The case law tells us anywhere between 6 to 8 is presumed to be an unreasonable delay. And here we are, it's already been 2 years since the offense date. Over a year since my client has been released from jail. Now, the reason for the delay has never fallen on the defense. It has always fallen on the state. When we were here in October of 2021, Judge Angelini was visiting judge. At that point, I'm sorry, if I can back up, please, Judge. On April 15th of 2021, we were here in court. The state had stated they needed more time to get medical records and decide whether or not they were going to proceed with the misdemeanor. So the case got reset, at which point we move on to October 22nd, 21, where Judge Angelini was visiting. Again, the state announced not ready because they still did not have any medical records. And at that time, they hadn't even ordered them. They knew and they had told the court, we need them. We don't know if we're going to proceed or not. So at this point, they get a reset. We move into December where we have a trial docket. And both sides announced ready, but the state still has not turned over any medical records. So it was recalled. We were recalled from November 17th, I believe, for trial. But once again, no medical records from the state. Now, Judge, as we move forward on May 5th, you will see in an order you signed telling the state they had 30 days to turn over this medical records. We come back 30 days later, June 6th, but we have a visiting judge where the state sought a continuance. And you can tell by the jacket, the file jacket, where the visiting judge had noted that the state's motion for reset heard and denied. And our motion for speedy trial was granted. At that point, the defense asserted that we still needed the medical records. The state, in order to avoid the granting of the speedy trial, said they would waive the medical records. At no point did the defense agree to that. But the visiting judge said the rest will be taken up with Your Honor. We come back for trial. And once again, at that point, the state had not turned over any medical records. This was just last week, Judge. So I re-urge my speedy trial motion. At this point, I guess the state realizes they really have to turn them over. So they get them and upload them into e-discovery, which I have not been granted access to yet. I've requested them and have not been granted access to them. What the state should have done in their due diligence was to email me immediately when they received the medical records, but they didn't. Now, this whole case, or my speedy trial, does not only pertain to medical records. The problem with this delay is now that the defense has lost 2 witnesses, Jorge and Carlos Cordova. They were there at the scene. We did have contact with them previously. We had contact with them in November of 2021. And now we no longer know where they are. So there has been a huge prejudice against the defense because we lost 2 important witnesses. The state in no way, shape, or form has ever answered for the delay in this case. They believe that because they issued a subpoena, they should be excused because the visiting judge excluded the medical records. They should be excused. And I'm sure today they will say, we turned over the medical records, so no harm, no foul. But that's not the case, Judge. There is a huge foul and they should be held accountable. And this case, my speedy trial should be granted. The case should be dismissed because of the huge prejudice that we have now faced by losing two of our main witnesses.
Well, tell me what you expected the witnesses to testify to, ma'am.
Judge, the two witnesses were there at the scene. They were going to be testifying that, and I have their statements when we interviewed them, that at no point did the complainant, at no point did the defendant hit the complainant, that the complainant started pushing one of the witnesses that was there, that she instigated a fight, that her brother came over with a knife, which is also corroborated with the police report, that at that point she started to hit one of the individuals. So the defendant got in the middle of them to break up the fight, at which point she started to hit the defendant, but at no point did the defendant ever lay hands on her, never hit her, never threw anything at her.
Okay. State, talk to me.
Yes, Judge. So let's go ahead and talk facts here. So the offense did occur on 3/6 of 2020. However, that instance was filed at large by my office and sealed. He was formally picked up on a warrant on March 6th of 2021 after we filed that, unsealed that case on 1/26 of 2021.
Wait. The actual event was March the 6th of 20.
Yes, sir.
But it was filed on what date?
It was filed at large on 1/27/2021. It was filed.
Okay.
So let's
So
go ahead.
we would agree that the clock on speedy trial started running on March the 6th, right?
No, Judge, we would not agree to that because the case was sealed. There was no pending charges. It was sealed.
Wait. My impression is the day he was arrested, speedy trial starts running then. It got nothing to do with subsequent acts or behavior. March 6th, the clock starts running.
Your Honor, Daniel Escobar for the state of Texas.
Yes, sir.
The defendant was not arrested when this incident actually occurred. The case was filed with our office at large, so the clock does not start until we formally file the charges if it's an at
Okay, he
large.
was not arrested March 6th then.
No, he wasn't. He was arrested. He was arrested back in
March 9th.
March 9th of 2021, but the state would argue that the clock for speedy trial did not start until January 27th of 2021 when the case was formally filed with the court.
All right, so arrested March 9th of 21.
Yes, Judge.
Actually filed on what day? January 27, 21?
Yes, sir. January 27th of 2021.
Okay, so that's when the clock started running.
Yes.
All right. Okay, so we're in agreement on that. So go ahead and continue, Mr. Delco.
So now, as far as her assertion that she asserted her speedy trial motion, the state's going to argue that's untrue. What she did on 3/25 after her client was picked up is filed an immediate motion to dismiss based on violation for speedy trial. So there was no assertion for a right to speedy trial.
Whoa.
It was a motion to dismiss.
Yes. I understand.
Filed on March 25th, 2021, when the client was arrested on March 9th of 2021. Now, as far as the length of delay, Judge,
You're saying that is not an assertion of the right to a speedy trial?
that is not. No, that's not. It's never been viewed that way by the courts.
And just for the record, Judge, I'm not saying that.
But I
That's-
don't necessarily agree with that.
They are
If
seeking a
somebody files a
dismissal.
motion, excuse me, if somebody files a motion for speedy trial, I understand that that's an assertion of the right. Now, tell me where I'm wrong.
Your Honor, if I may. So again, here what's occurred is it was a motion to dismiss for speedy trial. That is not the same as a motion for speedy trial. What the defense was seeking there in their motion to dismiss was a dismissal, not in and of itself a speedy trial. That's, I think, what Mr. Delco is attempting is arguing.
I think that's the difference without a distinction without a difference. It still gives you notice that they're seeking a speedy trial, whether it's in fact, I understand there's a distinction between saying I want it dismissed and I want a speedy trial, but that's still an assertion of a right to a speedy trial. Tell me I'm wrong now. I don't mind being told that, but how is there a distinction? Doesn't it put you on notice that they're asserting a speedy trial violation if nothing else?
Judge, it's asserting the state's contention once again is going to be they are asserting a motion to dismiss, not a speedy trial. So let's talk about the settings that we have had. We've had 7 trial settings. The state took not one ready. The state announced ready and present on all other 6. They want a speedy trial. Let's give them a trial. Now, as far as her assertion that they've lost 2 witnesses, those 2 witnesses could easily be recovered by a court subpoena. The information and the names were made available to them in that police report.
Were they not requesting medical records?
Judge, they were only requesting the medical records to see if it was going to be a felony. As soon as I received those medical records on Friday at about 3:30 p.m., I immediately uploaded those. And I also spent that Friday afternoon until about 9 p.m. reviewing those medical records for this imaginary exculpatory evidence that was supposed to be in there. As far as I can tell, there is nothing that's going to help her client there. If anything, it reasserts that it should have been filed as a felony charge. We are giving them a lesser charge, and he's getting off a lot easier, and he's looking at a lot less time than he would have been if he would have been in felony world. Point blank, period. In that time, we had COVID, so that should not be attributable to the state at all. We did not have any right, or I'm sorry, any control over that national state of emergency. You legally could not have jury trials without putting the jurors at risk. Now, knowing that the court is going to rely on Ex parte versus Sheffield, I want to make clear that that is actually currently up with the Court of Criminal Appeals for review, discretionary review, which is most likely going to result in an overturning of that case.
I hear what you're saying on that. And I know that that's you, as you pointed out and you sent to me, it's an Amarillo case. I call it an Amarillo case, just for the correct pronunciation. All right, I'm listening. Now, you're saying how much of the delay are you giving to the COVID?
That is a neutral reason that should be held neither against the state or against the defense. That's just something that nobody had control over. So it should be given a lot of weight, because we were here 7 times. I was here, let's be clear, I was here Friday. If her client was not here because the court had excused him, but I had not ready for trial. We had agreed to waive those medical records, and there was going to be no mention of those medical records. She wants a trial, let's give her trial. I am ready for trial, Judge. We could have had a jury tomorrow.
What was the charge, by the way?
It was a assault bodily injury, Judge. And mind you, it was a very serious assault bodily injury. Give my victim a chance and give the defendant his opportunity to be judged either.
You said it was a very serious assault bodily injury.
Yes, Judge, it was. This
Now,
victim
the event was on March the 6th of 20, but you didn't get the medical records until last Friday.
We got the medical records last Friday, but we also had provided them with discharge papers that were available to them long before those medical records. There was also a serious bodily injury letter that was also made available to them. She wants a trial. I am more than welcome to give the get to give her her trial. We can
I'm
vote
I'm hearing,
voluntary.
I'm hearing that, Mr. Delco. I'm trying to sort out the issues with the speedy trial.
Judge, there was no violation. You want to be quite clear because COVID prevented us from having trials for almost 2 years. We just now started trials back up in March or February of this year. I have announced ready on at least 2 of those occasions myself. We had announced ready prior to that because if we had not announced ready prior to that, we would not be here. This would not have been a matter. The court would have ordered us to dismiss this case a long time ago.
All right. Now, you have previously, Ms. Legareta, you previously had this motion heard, is that correct?
Yes, Judge, I did. I had this heard on June 6th of 2022, when the state asked for another continuance, as noted by the file jacket, and their continuance was denied. The only reason why the visiting judge withdrew his granting of my motion is because the state said they would waive medical records. And, I find it very insulting that the state wants to stand there and say, give her her trial. I asked for my trial back in October of 2021, and they announced not ready. We have been asking for this. We never were waiting to see if this was going to be a felony. This was a decision that was supposed to be made by Andrew Edelman at the time. He was the prosecutor who was dealing with this case, not Kenny. And he was the one who needed to speak with Jamisa Jarman to see if this was going to be a felony. So they needed the time to decide if this was going to be a felony. Why on earth would the defense fight for a felony? We would never do that. We would jump on the chance to try a misdemeanor. They want to say, this is a very serious case. It's not that serious if it was actually filed. The police filed this case with their office June 16th, 2020. They did not do anything with this case, Judge, until January 26th of 2021. And if it was that serious to them, back in 2021, when the medical records were first ordered by Judge Angelini, they would have ran and got that. Now, they don't get to say we gave her discharge papers and an SBI letter. The letter is not medical records. It's just not. It doesn't tell me diagnosis. It doesn't tell me actions. It doesn't tell me anything of the sort. But nevertheless, whether we have these medical records or not, they have requested 2 continuances at the very minimum, October 2021 and June 6th of 2022. And because of their actions, we have lost 2 very important witnesses. We can't solve it with a subpoena, Judge. We know that their information's in the police report. That's how we spoke to them in November of 2021. That information is no longer good. So we cannot subpoena 2 witnesses that we need. The state wants to jump up and say, give her her trial tomorrow. There's no way that's happening. I still haven't had access to the medical records. If the court was to say, Ms. Legareta, we're going to deny this, you can have your trial tomorrow, I'm still going to have to ask for a reset because I haven't been given access to the medical records. So they're still denying me my trial. I don't get it this week because I haven't seen the records. Whether it helps me or not is not the state's decision. That's the defense's decision. Not to mention, they waived it on the record. I know they're not going to talk about it. So if it's something I should be able to talk about, I have that right. I have the sole right to decide what the defense puts in and does not.
Judge, permission to respond. So she says in this
Kenny, can you hold the microphone a little closer, Kenny?
Yes. So she wants to talk about there's no reference to this injury in the discharge papers. There is a reference to how serious this injury is in these discharge paperwork. There is a reference, and I'd be more than happy to show her that right now again, but this is available to her. This has been available to her. Now, granted, she may not have access yet to those medical records because they were uploaded Friday at 4:30 p.m. It takes up to 2 days, at least 2 full business days, for them to be able to get that access. If she wants me to run upstairs and print off 713 pages, if not 714 pages of medical records, I'd be more than happy to have a file clerk do that for her.
And just for the note, Judge, did you hear him? 713 pages. And he wants me to jump on my trial tomorrow that I have not been even given one page of those 713 pages. Why didn't the state email me? They know how important the speedy trial was. Why didn't he email me? That's the question. The state should be held accountable. They have failed at every turn in this case. They don't care. They didn't care about your order. They refused to obey your order. Instead, they said, hey, no harm, no foul. We just won't mention any medical records in this very serious assault case. So they don't want, he wants to say she wants her trial. I wanted it since I've been hired on this case back in March of 2021. And I agree, COVID did take a turn on us, and I'm not counting the COVID months, but this case was sealed in the district attorney's office for the entire year of 2020. It existed, and the DA's office did nothing with it, nothing. And now they want you to say, please don't hold us accountable for ignoring your order. Please don't hold us accountable for denying this man his speedy trial. Judge, they're being busy, them not having enough prosecutors does not outweigh my client's constitutional right to a speedy trial.
Judge, I didn't ignore the court's order. Let's be clear. May 6th, you had ordered me to turn over those records. I did my due diligence. I sent the subpoena. I sent it for them that day. Literally that very minute you ordered me to do that, I literally issued the subpoena. Now, the defense has been wanting these medical records. It was not in the possession, control, or custody of the state. Brooke Army Medical Center is an arm of the United States federal government, if we want to play that card. That is a third party. She had the ability to go out and seek a subpoena. She did not do that herself either. You cannot put that full burden on the state. What we have in our possession is what we have. If we don't have it, we do not have it. I did not have it until Friday at 4:30 p.m.
Which I also find very funny, since their complainant can ask for their own medical records. You don't need a subpoena if you're the patient. They never reached out to her to get those medical records. And for
Okay.
them to say this is, yes, sir.
All right. Mr. Delco, were you here when, was it Angelini that at first granted it and then changed his mind, or was it another judge?
Judge, I was not here when Judge Angelini was here. Judge Henderson is the one that waived, that decided to take back the motion because we had split the baby.
Okay. Have you reviewed the medical records, Mr. Delco?
I have, Judge. I spent literally hours of my weekend when I could have been spending time with my family. I didn't leave the office until about 8 p.m. that Friday reviewing them. I reviewed them on Saturday and Sunday when I could have been at mass or going to the park or volunteering. There is nothing, as far as I can tell, that is going to help our client. If not, it's going to make it worse. Now, if the court would like me to produce those records in camera for review, I'd be more than happy to do that as well.
Judge, whether they're produced in camera does not take away the defense's right to decide what comes in and what doesn't come in. I don't understand why the state completely ignores that fact. He spent 2 days going over them, and I still don't have access to them. And he wants me to have a trial tomorrow, even though I'm going to need 2 days to go over them.
There's not going to be a trial tomorrow. There's no question of that, period. Just to assuage any worries on either side. If the evidence, if the medical records have not been turned over to you fully, then there would not be a trial until such time as they are turned over. All right, no question. Ms. Legareta, how long are you saying that there was a delay?
Judge, at the very least, from April 15th to 2021, when the state stated to the judge at the time that they needed more time to decide whether they were going to proceed with the misdemeanor or go forward with a felony. So since April 15th, 2021.
Judge, that's less than 1 year ago.
It doesn't have to be a year, right? It has to be 6 to 8 months.
Okay, but it's still less than 1 year ago. So therefore,
sorry.
it's not a lot of
Are you
time.
sure it's less than a year ago, April 15th of 2021?
We're about a year and 2 months. I'm sorry.
So it's over a year.
So a little over 1 year, Judge. The court has already said previously the 2-year delay is not long enough to violate a defendant's right to a speedy trial.
What?
A court has once said that a 2-year pre-indictment is not a long enough delay for, and I can produce case law for you to that effect, saying that 2 years is not a violation. So if that 2 years is not a violation, 1 year and 2 months is not a violation.
Oh, okay, but the state literally just said 2-year pre-indictment. This case was filed by April 15th, 2020. It was filed January of 2021. So that case is not on point if it's a pre-indictment. This has been filed already.
So even if it's a pre-indictment, there would have been no delay after it would have been filed.
Not to mention, Judge, how does the state?
Hello.
Yes, sir.
Yes, Judge.
There's no question that the delay is in excess of 8 months, Mr. Delco.
Correct. And the state will concede that.
And if so, then there is a prima facie, or I shouldn't use that term, but there is a presumption of delay is excessive and prejudicial.
It starts the trigger, Judge, to go forward with the analysis. It starts a trigger.
Yeah, that's Barker v. Wingo. Now,
But then again, we haven't heard any testimony to make the decision to know whether or not it is a clear violation of this defendant's right to constitutional trial. The court can't make a decision without hearing that.
Judge, I can have my client on Zoom right now to call him to testify, and he will testify not only to missing witnesses, but to the anxiety and concern, the fact that it's hindered him at work. It doesn't get better for the state should my client testify.
well, I would tell you that as a matter of record, it is a concern that there is no testimony at all concerning the issue of what harm there is as a result of the delay. You're going to have to present that. We're not going to do it today because you don't have your client here. Is he available within the next 5 minutes?
Judge, he's available in the next 2 minutes to log into Zoom. I just need the Zoom login.
Judge, the state is going to object to her client appearing by Zoom.
Why? They get to question him the same
We
way.
can't judge his credibility with him sitting here, and neither can Judge Longoria.
Judge Longoria is via Zoom.
Mr. Delco, what is your objection now for the record?
My objection is that her client is not here.
And if she presents him on Zoom,
The state is still going to object, Judge.
on what basis?
We're gonna, because we don't have the opportunity to sit here and look at him and to get body dressers, and you're not gonna be able to get body dressers either. So if Judge Longoria, I know that you're supposed to be on medical rest, but if you want to have him here, we would request that you be here too as well, sitting as a fact finder.
Mr. Delco. All right, you're objecting to, essentially, you're objecting to the conduct of this hearing on Zoom.
Yes, Judge, if we're gonna have the witness here, I'm objecting to having it on Zoom.
All right. I'm gonna recall this in 1 week. Ms. Legareta, you bring your client in 1 week to
Yes, Judge.
establish the at least one of the factors in Barker v. Wingo.
Yes, sir. Well,
Right now, in this hearing, we're absent that. Now, the other side of it is, who took the record on the previous hearing where the judge granted it, then ungranted it?
I believe it would have been Miss Torres. I'd be happy to check with Linda. She did give us that name Friday when you ordered us to prepare for a speedy trial hearing. She does have that information available to her.
Kenny, I'm really at a disadvantage here on hearing you, especially when you tail off at the end there. All right, did y'all understand what I was saying?
Yes, Judge.
yes, Judge. And it's Ms. Torres who took the record, Judge. Linda has that information. Kenny had gotten that information from Linda on Friday, and he said he was going to reach out to see how much the transcript would cost so he could take it to Juanita.
But it'll actually be going back to Jamisa now, Judge, because
Excuse me.
Jamisa's back.
Excuse me. Who took the record? Do you remember, Ms. Legareta?
It was Miss Torres.
Ms. Torres?
Yes, Judge.
All right. Linda? Oh, Linda. Listen, Linda.
Yes, Judge, I'm right here.
Okay. I want a transcript of the previous hearing that was on the speedy trial that was heard, because I don't know if the factors from Barker v. Wingo were established at that point, but if they were, then we have an issue of the facts already being established or not.
Okay, are we talking about June 6th?
Yes, ma'am, Linda. It would have been June 6th when Judge Henderson was visiting.
Okay,
All right, let's get that right away. I don't know if we can get it within 1 week. That might be pressing the court reporter. Let's make it 2 weeks. I hate to do that, but I don't need to reinvent the wheel. If the testimony, Ms. Legareta, I know what you're asserting, but as a matter of record, I don't have that in front of me. And I apologize. I should have probably gotten a transcript before. I would expect that we can get it within 2 weeks. So let's recall it in 2 weeks, Linda,
yes,
at 1:30.
Yes, sir. And this will be in person, correct, Judge?
That is correct.
Yes, sir.
And Judge, just for the record, by the time we come back, I don't want to hear Ms. Legareta say she doesn't have access to those medical records because they would have been available for her for a while by then.
And Judge, I will say whatever I'd like to say.
Hey, guys. I'm not going to play referee between you two debating each other. Direct your comments to the court and we'll go from there. But I do appreciate that you are, both sides in this case are advocates. I respect that. But let's, we don't need to get a little testy with each other. Hey, you're professionals, just like I am. Or at least I think I am. But all right, guys, then 2 weeks, we're ordering the transcript. I will read and see what's said and what's not said. And then we'll go from there.
Thank you, Judge.
Yes, Judge. May I be excused?
Yes, ma'am. Thank you.
Thank you, Judge.
You're welcome.
Veronica, can you come and see me, please?
I'm sorry?
No, I was talking to Veronica, Judge.
Oh,
Yes, I'll be right there.
Thank you.
all right. Where's Ms. Morgan? She was scheduled at 1:30, right?
I believe that client is in,
That's here.
oh, he's here?
That one's here.
Oh, so it's
The 3 o'clock is not here.
1:30 was Payne.
There she is.
No, the 3 o'clock is Payne.
1:30 was Payne. My notes say 1:30 is Payne.
Oh, I was told that 1 o'clock or 1:30 was Payne.
Oh, yeah, that's all right.
Okay.
Are we ready on Payne?
Judge, Mr. Payne is the one that's in jail. He's in custody in another county, so that one's not going today.
So Judge, can I explain what happened on Mr. Payne?
Yes.
So Mr. Payne, I believe he started probation in Gillespie County in July of 2020. He was then arrested on this DWI in September of 2020. He had been reporting to what he thought was probation here in Bexar County every single month, paying his fees. However, Gillespie County filed a motion to revoke his probation at some point in the last 2 years. And he went to report to Llano County and they arrested him on a Gillespie County warrant for the MTR. So he is in Gillespie County. I'm sorry, he's in Llano County jail. I have filed a motion to get bond out of Gillespie County. And once I get him on bond, I'll get him back here for the motion to suppress.
That poor guy.
He was so upset. His brother's been calling me. He reported on Monday. And the prosecutor in Gillespie County is on vacation. And her counterpart would not agree to a bond without knowing the facts of the case.
What is he charged with in Gillespie County?
He is on probation.
I don't know if it's relevant, so I would rather not say.
No, it's relevant because we're gonna see the report anyway. He's gonna see the report.
Why would he see that report?
He sees the.
It don't make any difference. I was just wondering if it was such a heinous crime that somebody would have a difficult time in agreeing to a doggone bond.
I haven't seen the report yet, but he's gonna see the report too.
Well, he won't see because it's Gillespie County's MTR.
But it'll show up on ours.
Okay, so paying in the, what you call it, is not available.
He is not available.
Involuntarily.
And I thought involuntarily, yes, sir.
You thought what?
That's yes, sir. Involuntarily, yes, sir.
Okay, so then now we have,
Is your officer gonna be here at 3:00?
No, use that forward motion.
Okay, can we do a forward motion then?
Jason Holder.
And he's outside, Judge. Let me get him.
Those are for 3:00, Judge.
Are you ready for him though? Oh, do you want to look over? Okay. Oh. I'm okay if the state wants to grab lunch. But yeah, you've seen that, right?
You haven't had lunch?
I have not, Judge.
Well, go get a bite, I guess, and especially since Ms. Morgan is being gracious enough not to hold your feet to the fire, make you sit there and be dying of hunger pains.
It's in our DACC.
So what's the charge on Jason Holder?
And Judge, I have filed a memorandum in support. I want to make sure you have a copy of that. I filed it, I don't know when.
No, but what's he charged with?
DWI.
Oh, what a surprise.
Shocker. But let's let Mr. But I don't know.
DWI first, misdemeanor B?
It's a class A DWI second, Judge.
Okay, it's a second. All right. And this is what kind of motion?
This is a motion to suppress.
Okay, yeah. Okay,
And do you have, I filed a memorandum of the case law in March. And back then I had talked to Mr. Stone about it. I think I've talked to Mr. Deco about it, but he doesn't remember.
This is the one that Ken was talking about, a radar.
Yes.
And we gave you that, right?
Oh, I have that, yeah.
Okay.
The Eagle.
Yeah, because I know that's what you kept on asking. Copies.
Yep.
Kenny, go get your lunch and I'll be sitting here waiting.
What time do you want us to come back, Judge?
30 minutes, Ken?
30 minutes is fine, Judge. Thank you.
Okay, so
Okay.
see you at
If you need-
2:15,
if-
Judge?
If you need a few more to get an extra chew or two, let me know. But
Thank you, Judge.
Kaylee, we'll come back at 2:15, 2:16.
Okay, see you then.
All righty.
Judge,
Yes.
for Veronica, we're gonna do Friday the 12th at 1:00.
But tell them why, that's not my fault.
I know.
Friday, August 12th.
Yes. Because I have a motion to suppress on the 8th, and she can't because she might be starting trial. I have two motion to suppress on the 9th for David Dilly. We have a special trial setting for Joe Stenberg. And then that would give us Friday the 12th at 1:00, 1:30.
That's what you got. That's what you got. Make
Okay.
sure the state is aware.
Okay.
Thank you, Judge.
You're welcome, Veronica. Take care.
So what
Can
do
we go?
they- I don't know if I can. I can't.
Join room 1 and then ask the Longoria to go. See?
Okay, so judge here.
Assigned to room 1.
Okay, and then I can join, right?
Just tell the judge,
Oh.
go to room 1.
Okay, hold on. Need it myself. Judge,
Yes,
can you please go to breakout room 1, please?
I'm sorry.
Can you please go to breakout room 1?
Am I being put in the corner?
No, I just please.
All right, I've returned to main session.
Now we're in the main session, Judge.
Okay,
It can be via Zoom, correct?
Yes.
All right.
Well, no, the plea,
Yeah.
if it's a plea.
Yeah.
The plea would have to be in the afternoon. Can we do it on the 3rd?
I don't know if that's gonna work.
What?
Setting 1 or 2 days for pleas. Hey, I remember one day I had 12 pleas
I
in
know.
one day.
Well, I'm got some right now. I have 2 on the 3rd. I have 2 on
I
the,
know, but if they show up like this morning, they show up for a plea, they got their paperwork, let's get it
no,
done.
they don't have the paperwork, Judge. We're gonna
I
have
see.
to go through all that mess again.
I got you.
So, okay, so unless you want to set them that day and I tell them, come back that afternoon, the only thing is on Mondays and Tuesdays, we have motion to suppress this.
Vamos a ver.
Okay. Can we do Ashley, can you come see me real quick before you start?
It's 2:16. Kayleen, you ready?
Yes, sir, sure am.
And State, where to go? Kenny, you ready?
Oh, did you mean to start again, Judge?
Say, are you ready?
So we're trying to figure out how we're going to get the video to you. I haven't quite figured that out yet, but I'm trying to get it to, because I think what I'm going to do is probably log into the Zoom and then put my, my personal computer up there so that you can see the evidence. I think that's what we're going to have to do. So I might have to log into the Zoom link for you to be able to see.
Y'all figure it out. I'll just sit here.
Do you want to move forward today, Kenny?
Eh?
Okay. Judge, on this particular motion to suppress, it's there's an Eagle video and a dash cam that I think is both relevant. I mean, even on the body cam, the officer says.
There's a what video?
There's an Eagle. So Eagle is that helicopter in the sky.
Up above?
Yes.
No kidding.
There's a dash cam.
I've been here almost a little bit close to 8 years, and I've not had that presented, the Eagles video. The Eagle.
So how do you think would be most advantageous for us to present it to you? Would you like to watch it via Zoom or burn it on a CD and bring it to you?
I guess I can drop it to your house or something.
That's up to you. It's your case. You tell me what you want to do. Either one is effective, right?
We can do both. That way,
I just don't know if I could assume it's going to. Have you seen this? Is it going into your stream with the Zoom? I mean, have you
Yeah.
seen it is?
I've never seen it via Zoom, but I've seen it via video, and you can see on the Eagle, you can see pretty accurately.
Mhm. This is like 10.
And do you have a copy of the offense report for the judge?
I do not. I actually have name.
Okay.
That's. Who's this guy's last name?
Holder. Because a lot of times before we had computers in here, the judge would just go back and watch it in the office. I mean, it's really good. Have you listened to one that like the show it into the car beats? I give you a name to watch. I mean, how did they catch you in the car if they follow them? So they're still looking for.
Okay, so this is like done.
Yeah. They're just looking, they're scared.
Because my whole issue with this function is using it like with it being back.
So that's like, it's not a reasonable, that's my problem. It's not a reasonable belief.
Judge, at this time, the state is going to take a not ready for this motion. I think I need to sit down and further review and decide whether or not we're going to go forward with this case.
All right,
I think there's just probably a lot of problems that it may not, in my honest belief, survive a suppression hearing.
well, it's not a matter of survival or not. You'll survive it, Kenny. All right. The case will be reset. How much time do you need, Ken?
What month are we in again? Are we in July?
July 25th.
Hey, Linda, what dates do we have in August?
I can go back there.
For what?
A Wednesday
Motion to suppress.
Motion to
A
suppress.
Wednesday afternoon motion to suppress.
Because I know that we have the one on August 1st, even though it got reset from August 22nd. So do we just want to put Ashley Morgan on August 22nd for Jessica Gonzalez's original date?
We can, it's at 2:00.
You want to do 2:00?
Is that a Monday?
Yes.
I don't, it's the first day of school for one of my kids, but that's okay. He'll survive.
No,
No, that's okay.
no, Judge,
I'll bring them dinner. I'll bring
no,
dinner.
we'll pick a different date that works because I don't want, I think that, parents should be with their kids on the first day of school. Judge, I like to be fair to the
He
kids.
did, and also to be fair with the prosecutor, he did ask his Tia on the last day of school to pick him up the first day of school. So I'm okay. He loves her more than me. I'm okay with
I don't
that.
know. If that's true. All right, I guess we'll go ahead and do August 22nd.
It's
Judge, my apologies at the court. Normally, I try to review cases before I sit down, but this is not one I had the opportunity to touch yet.
And to be honest, this was a Mr. Stone motion that I worked with way back in March. And I think the first couple of times it got set, the state didn't get notice of it.
Okay, no problem. Stay not ready.
Yes,
Noted,
Judge.
noted on the file, Linda, and then we
Thank
have
you.
reset to August 22nd, you said, Linda?
August 22nd.
Doesn't have to be a Monday, by the way, or do you prefer Mondays, Ms. Morgan?
I'm good any day, Judge.
Judge, my concern though is that normally we have jury selection on Wednesdays and then Thursdays we're probably going to be in trial. Friday, I'm sure nobody wants to be here on a Friday, but
I am available on Fridays. Do
you want to do a
kid
Friday?
yourself
then?
about that.
Let's keep it Monday, the 22nd.
She wants. We'll get it. We'll agree to keep it Monday, the 22nd.
All right.
But while we do have her here, Judge, there's actually another off docket matter that we need to approach on, so she doesn't have to come back tomorrow.
Yes, please.
Wait, question, is this on Payne or Holder?
This will be on Holder.
Okay.
The reset is August 22nd for Holder.
And then if Holder gets or Payne gets out of jail ever, I guess we can just put him on that day too. So we can just kill the two birds with the one stone.
Tomorrow is the what? The 28th?
Yes, sir. Tomorrow we have a contested violation report on Jessamine Brown, and I'm getting you the cause number.
27th, right?
27th, yes.
27th, yes, Judge.
Okay.
Me too.
Okie
So she applied.
dokie.
So Judge, on Jessamine Brown, it's cause number 687147.
687-147.
147. The
No, what? 147.
yes.
Oh, that's the 20. There's my 27.
This is set for tomorrow at 1:30 in the afternoon.
So we don't go to trial.
That's correct, Judge.
What's the story with Valachek tomorrow, Linda?
I thought Kenny said that was getting dismissed.
I am pretty sure it's going to be a dismissal, but I need to check with ADA Vance, who is off and with his wife in surgery at this time. It's also his birthday, so I have to call him and ask what he wants to do with, because that's not my case. My case was Mr. Valdez's.
Okay, let me finish this one then with Ms. Morgan. This is Jessica, no,
Jessamine,
Jessamine.
Brown,
Brown.
yes, sir.
All right, what are you doing with that?
So the state had filed pretrial services, filed a first violation report on July 11th, 2022, on or about that day, July 11th. And I had reviewed, I'd asked the state, and they were very cooperative. They provided all of the offense reports regarding that alleged violation. And the state agrees that there may not be enough proof to prove which party contacted the other party. So we would like for you not to act on the violation report and give her zero.
Judge, we're going to request zero tolerance. I still would like no contact with my victim. If she screws up, I am requesting the court remand her without bond until trial.
You want to remand her?
Not right now,
Not right
Judge.
now, not right now.
Oh, okay. Because I was hearing that this is gonna go by the wayside tomorrow, right?
Yeah.
So tomorrow, or well, we're hoping you do it today, is that you continue her on bond with the same conditions, which is zero contact, no contact with Jonathan Cruz Castro, and with zero tolerance.
Is there more one person, no contact? Linda, you
No,
getting this down?
I'm writing it down, Judge.
Okay.
I just think that, as Ms. Morgan said, with the evidence that we received, it's just not going to be easy to prove up that violation, Judge. I have no way to see who contacted who first.
You smooth talker, you, Ashley Morgan.
I have talked to her quite frequently. Would you like for her to appear via Zoom tomorrow, Judge, so you can talk to her?
Do you think it's necessary?
I honestly believe it may be necessary just so that
Then
she's
let's get her to show up.
just to get her to show up and say, you know, the court is not going to tolerate.
All right. After the docket, it's okay. Here's what I'm understanding. After the docket, and after I talk to her, you will file a motion to withdraw the MTR or whatever.
It's a
it says.
violation report, so you can just act on it.
Yeah, it was a violation report, Judge.
So we're going to just simply, after everything, all the dust is settled, we're going to continue her on with the same conditions, and particularly no contact with two individuals.
With one
individual judge. It's Jonathan.
And we're going to change it to zero tolerance.
Correct.
No, actually, the warrant has been recalled.
The warrant has, so initially, Judge, before I was able to get a hearing, you had issued a $4,000 bond increase with full GPS. So you've already recalled that, but I still wanted a hearing.
Judge Rodriguez recalled it per
Yes.
Daniel Escobar, yes.
Yes, Daniel Escobar agreed. But tomorrow, we had set up for a contested hearing tomorrow. So tomorrow, if I can have her appear via Zoom, so that way the court can instruct her that she's on zero tolerance and to reiterate how serious this is.
Okay, and the charge is assault bodily injury, married.
Yes, it's her alleged boyfriend.
Okay, I understand it's an allegation. All right. Then we're among ourselves, we're agreed that this is going to just be continued, zero tolerance and no contact. All right.
Yes.
Linda has the specifics. We'll include that in the file.
And do you want her to appear via Zoom or in person tomorrow at 1:30?
What do you want? You know, it's your case.
I would prefer via Zoom.
All right. Make her
State
show
of
up on
Judge,
Zoom.
sorry.
Just kidding.